Good morning. Good morning. Good morning. Happy Tuesday. It's May 16th. I can't believe we're already actually in the middle of May. We've got a new Dave Matthews Band album dropping. The summer tour is getting kicked off. Do I calendar my year around my children's school schedule and Dave Matthews concerts? Partly, but summer concert season, I am ready. I'm not ready always for the humidity, but I gotta admit that the last few days have felt kind of nice that it's warmer outside. Yes, there is some humidity in the air, but it's better than it being so dry you can't breathe. So I've got my coffee today. I've got my cursey words ready to go for some of the stuff that's going on. But we've got a lot to cover today in Idaho. There are a number of new filings. I'll probably check before I'm done streaming today and make sure there's nothing else new, because it seems like every time I'm done streaming, it's like, and another one. So I'll probably do that. We're also going to talk about just a few other cases that I found interesting. And one is a follow-up. One is regarding Chippendales, and I just couldn't help myself. I was like, oh, we're talking about that. So replay crew, love you. There's always timestamps down below. For those of you that are fairly new here and are not members, it is okay. But if you are not on the email list, you are missing out, because we have done a pre-release of a collab that I did with Jen Gerard. And right now, if you are not a member, the only way to get access is through lawneralert.com. So if you go and join lawneralert.com today, you will get access to that before things go on sale to the public. So if you see the Law Nerds chatting about that in the chat, that is where you want to go to get access. You might have seen it around social media. People have already started getting their collab boxes, and you will see me wearing my lip glosses from the collab today. So that's what's going to be happening today. I'm wearing Hearsay, but you will also, and have seen me wearing Objection for weeks and weeks and weeks. And y'all are like, Emily, what color are you wearing? And I'm like, I'll tell you later, I promise. So I've been wearing Objection and Hearsay on streams. They are glorious. They are buildable, but they are not overpowering. For those of you that are nervous about a lip, don't worry. Don't worry. I've got you. So if you want to get access to that before the public does, lawneralert.com is where you need to go. So all of that. If you are members, again, go look in the member spaces and you will get taken care of. There are posts there. So with all of that, coffee, cursey, topics, I think we've got to talk about this, what happened to last week's stream a little bit. So do you guys want to know, after I roll the intro, should we talk about it? Should we talk about it? We'll talk about it. Let's talk about what happened to Thursday's stream real quick.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
So, y'all know that I have ADHD, right? Oh, the coffee's really good this morning. Y'all know I'm ADHD, right? So one of the things I sometimes struggle with is impulsivity. This was a bigger challenge when I was younger. Now I think my age and general tiredness have balanced out some of the impulsivity, unless it comes to online shopping. And then my sons are like, Emily, they generally say, Mom, you bought a new Nintendo Switch. Yes. Why? It's pretty. That's not a reason to buy new technology. But isn't it though? So sometimes when it comes to maybe dealing with the impulse to be like, I see it, I want it, I got it, that can be a challenge. Look, when I was in college, this is just real talk. I am not proud of this, but I'm also trying to not hold shame around things due to my ADHD. When I was in college, look, I love my parents. My parents are great. My mom listens to every single podcast episode, doesn't watch a live stream to save her life. But my parents didn't talk a ton about money. I had a job starting at 15 years old. I worked. I generally had My parents are like, she's working, she's paying for gas, she'll figure it out. I didn't know that my car needed oil changes, and that caused a lot of issues because nobody told me these things. And I'm like, I explicitly need to be told things if you expect me to like know to do them, because how else do you know? And then by the time I got to college and got a new checking account, because I'm sure these predatory practices have stopped, but is it really a predatory practice if what they're offering you is literally like a $3 candy bar? And they're like, there's free candy bars, sign up for your new like checking account. And I'm like, sure. I didn't realize that the overdraft was not actually like a part of my balance. So when I was in college, I definitely ran into some money trouble, some debt trouble, and debt because a lot of the time it wasn't sometimes it was a cash flow issue, but it often wasn't a cash flow issue. It was a, wait, when are bills due again? And wait, I need to like mail stuff in. God, online banking and automatic payments would have saved me so many fucking late fees. The way I would have been saved by like just making that automatic minimum payment in the 90s. So I kind of learned the hard way that, I didn't always understand things that maybe I felt like I should have. And oftentimes I was really embarrassed and ashamed to ask for help because it felt like everybody else knew what they were doing. And I was like, how does everybody else just know this stuff? Generally, someone told them. So I talked to my kids a ton about money. And I talked to my oldest because he can get oh my God, my friends all just bought this skin in whatever game it is. And so I'm like, okay, I understand this seems really fun right now, but do you really want to spend like $20 in this game that you don't play very often? Can you maybe buy it in the morning? And so this is something I do for me. This is something that he's doing too, is like let's try to sleep on it. It's really hard when there's sales though. And like countdown timers, it's like, but if I don't do it right now, I get it. And sometimes I'm like, make the decision, because he has to make the decision. Because then if later he's like, oh yeah, now I want to buy this thing, but I spent the $20 on the thing. I just remind him, hey, where did that $20 go? Oh, it went to the skin in the game. Is that worth it now that you want to do this other thing? And trying to let him understand that, oh, I spent my money there, so now I can't do this other thing, and the missed opportunities of it, so that he can experience it in a way that's not going to be like detrimental to life, right? So impulsivity being an issue. On Thursday, I knew that the Vanderpump trailer for the finale was dropping. I also know that NBC Universal can be total dicks when it comes to taking down streams. But in the oh my God, it's happening of it all, I was like, we'll just stream it. They don't seem to care on Instagram and short form content. They're like, react to it, stream it, use clips of it, share it, whatever. But on YouTube, whoever is dealing with the copy system for YouTube are so salty. So if you were here live, you saw it. If you were not here live, you were trying to click on Thursday's stream going, why does it say it's been claimed by NBC Universal? Because I overrode my own better judgment and went, it'll be fine. Fast forward, it's not fine. So we clipped that part out of the live stream. The live stream is back up for you to watch, but apparently reacting to the trailer that they are fine with on short form content platforms, Instagram, TikTok, is not cool on YouTube. I loved it. I regret nothing. The only thing I am frustrated by is the frustration it caused any of y'all in the replay crew trying to get back on and watch it, going, what happened? Oh yeah, we absolutely watched it multiple times. I'm going to clip it out. I have clipped it out of the YouTube video. I'm going to clip it out of the video and put it up in the member spaces and get you guys a link to it so you can see it. Because look, I needed to react to it. I had thoughts, and maybe I will do some of those reactions to my thoughts on tomorrow night's episode, the way I've arranged my entire work schedule, so that tomorrow night I can sit down with a whiskey and watch Vanderpump Rules, a show that I did not watch 2 months ago. And I am fucking gripped. the way I am gripped by this damn show. And I saw Elise Myers talking about it and I was like, right, everyone. And then I saw Andy Cohen posting on Instagram that he was watching the reunion on a flight and no one seemed to give a shit. I was like, put me in. Like, are you on Delta? I fly Delta. Why are we not sitting next to each other in first class? I'd be like, bitch, give me a headphone. Like, give me an earbud, whatever. We're watching this. Andy, we're watching this together. No notes, flawless, 10 out of 10. Ariana's dress is slaying. Whoever her stylist is, killed it. And here's the thing that I'm torn about is because the real pain to the real people is not like, and shouldn't be entertainment. So I feel like I'm living in some weird fucked up reality TV version of Gladiator where I'm at this point, I am just rooting for her to excoriate Tom, but that's where I live. I'm just like, ugh. You guys can't binge watch Vanderpump in the UK. Do you not have Peacock? Peacock is great. We're going to be talking about streaming services and Peacock and stuff later on. There's updates in the South Park suit, but there's like a bunch of updates and I'm going to do them all in one episode. Tomorrow's podcast, I'm talking about all the things going on with Murdaugh. The members that were in the behind the scenes, I think enjoyed the episode. I think Murdaugh needed to be distilled with like all of the context for what's going on now. And then, he's making statements from prison in letters to friends that the media is reporting on. The media is not reporting on the fact that he's trying to like grab money out of the pockets of the Satterfield boys. That's not being reported on, but Alec Murdaugh says he didn't do it in a letter to a friend. That's being reported on in Rage. So with that, we're going to talk about a lighter topic today. We're going to talk about a heavier topic today, and then we're going to talk about Idaho, which is its own topic. So that's what we're doing. And then Q&A. So with all of that, y'all, I appreciate you. Thank you for being here. I couldn't even stop today. Like, I watched the little teaser trailer for tonight's episode like 3 times today. I was like, like Ariana's just sitting on the couch being like, and this is how I discovered it. And have you guys ever had this moment with a friend who has discovered that someone is cheating on them? Have you ever been there for that moment? Like, it's visceral. I was with friends at a Starbucks. And my friend started getting texts from her husband, who was on a business trip, that were clearly to another female to meet up with him where he was out on the business trip. I think he was probably a little bit intoxicated because he didn't realize till the next morning. But I was sitting there as she was getting these texts. And when I am your friend, like my brain first goes to homicide. Like homicidal rage is real. And I'm just like, and then we plotted. And so we went through it. It became very clear through the graphic nature of those text messages what he intended to be doing with this individual when they meet up on his business trip. And so it was 1 or 2 options. And instead of confrontation, the option she chose was done. So on his next business trip, everyone packed up her apartment while he was gone and left. Took the dog, took the furniture, left a note, and was out. And left the, conversations about the text message in a note, and then filed for divorce. So it was, yes, I was absolutely like, we ride at dawn, but also this is my ride or die bestie. And I was like, no, if you don't want to excoriate him, if your thought is eat yourself out of this immediately, like move immediately, this is a good plan. I'm here for you with this plan. So it was just a move everything. It's like, oh, when's the next business trip? TikTok, I'm out. I don't think I would be able to comport my face to still be in a house with someone after that. I don't know if I would be able to do that. She is a stronger human than I am. I think fighting would be I think rage fight, but I don't know. No, I do know. Every time I've been cheated on, rage fight there has been screaming. Um, because honestly, if you want to leave, if you don't, and this is obviously pre Dr. B days, but if you don't want to be with me, just tell me and go. It's like, I'm not going to die without you. It's fine. Go. I will be on to the next. But don't make me look like an idiot. And this is why I think I feel so strongly for Ariana. A lot of us have been cheated on. And it's not the cheating, it's the disrespect, right? If you want to go be with someone else, go be with someone else. But the disrespect to embarrass someone, to allow the person that you're sleeping with to stand there and play pop quiz about your body image, about how you don't feel like you want to be intimate with your partner because you don't feel good about yourself. And that person is sitting there gleefully having that conversation with a fucking grin on their face and then talking about it. That disrespect, how do you disrespect someone you cared about like that? It's really the disrespect. The cheating is disrespectful too, but then the letting it go on for the months and the months and the months and the months. And then it's awful. But most of this behavior, I feel like a lot of this behavior should just stop. People learn these things in high school, right? You know that there's a song popular that talks about the 2-week teen dating limit. And it's like, look, if you want to go be with someone else, tell them. Just go be with someone else. Like, just be upfront about shit. I think teaching kids to just be upfront about how they're feeling is something that we all strive to work on as parents. Like, just tell me how you're feeling. Just if you don't want to be with somebody anymore, tell them. Yeah, their feelings are going to be hurt. Yeah, it's kind of messy. Just tell them. Just tell them and move on. It's going to be fine. Yes, Chap by Not a Surf. It's a great song. It's a great song. Some of you are like, see, you said popular and I thought wicked. I know both, but I was thinking High Ponytail Not a Surf. The 2-week teen guide to popularity or whatever. Not popular. Wrong one. All right. Let's get into our chat. Now I feel like I've mentioned both populars. I'm popular. Different one. Oh, the 90s music that I love so hard. All right. It's why we've gone to we've gone to a record player at our house. Our teen was fascinated. I got Dr. B one for his birthday, even though it seems to have been a present for our teen because he is gripped. But it's really fun listening to the albums that we love all the way through. And the music that we have, maybe I'll put this up on Instagram if you guys are curious, but we have multiple Offspring records, Stone Temple Pilots, No Doubt, obviously, Tragic Kingdom, if you are curious, and a few other, those are the ones we've listened to the most. There's a little Taylor Swift in there for me too, but it's Prince, but I will share. And then I've got a limited edition Dave Matthews Walk Around the Moon album coming in purple. I'm so excited. All right. Let us talk about the things. Oh my God, can I tell you something exciting? This might not be exciting. To those of you that stream or those of you that mod on channels, I was having a conversation with Streamyard. I love being a Streamyard ambassador, but we were having a chat and they were like, what is the one thing that would make life easier for you? And I'm like, look, if you could autosave super chats, it would make my life so much easier. Guess what feature rolled out at the end of last week? Yeah, auto-saving super chats. So now, no matter what trial we're covering, no matter what's coming in, we're ready. We're ready for super chats. I'm so excited when they're just like, we've got it. Autumn, the ADHD RD, my MD gift was purple hoodie, Objection mug, Bring the Jury sticker, and lip gloss set. Cheers. Cheers and congratulations and happy Mother's Day. Totally posted swatches on my IG. I'm going to go share those bedazzled nails. I haven't been on IG a ton over the last 2 days. I will. Oh, Jen Gerard, good to see you in the chat. Happy birthday to me. Happy birthday to you. Today is also the premiere of the Joanne Dewberry JD's JD's new pick and 1 year anniversary of Camille's first day of cross-examination. I didn't realize that today's the 1 year anniversary of the cross-examination that will go down in history. That will go down in history. I didn't know Rob talked about it on Friday night. Frenzy. Very cool. It's so good. It's so good. It's just so helpful. So it had been on their list and I was like, can we bump it to the top of the list? This, for streamers that do what I do, this will be just, yes, this will be so easy. So it's really nice to be a non-gaming streamer and have people listen to your suggestions. It just makes me feel so validated. It just makes me feel so validated because a lot of the streamers, gaming streamers, do things differently than like all of the other streamers. So it's nice to feel like a streamer that's heard. We need to talk about Chippendales. Are you guys not like Chippendales, Rescue Rangers? Not those Chippendales. The other ones, the like, we'll ride it, my pony. Those Chippendales, those ones. I'm hoping this is going to be a quick bits. I don't know if I can promise you that it will be though. Quick bits. Damn it! I hit it too soon. Quick bits. Yes, think more Vegas Chris Farley Chippendales. So this comes to us from Law 360, and I'll pull up the complaint if you want to see it. But there is a trademark suit over Chippendales. And yes, more save a horse, ride a cowboy. less actual chipmunks. So the male exotic dance company Chippendales has filed a lawsuit against a man who claims to be the heir and rightful owner of the company's trademarks. The amount of scandal that's going on with this is delicious to me. And it's a trademark fight, so it's like we're gonna sort it out, right? But also, a lawsuit against a man who claims to be the heir and rightful owner of the company's trademark, saying that he has been illegally interfering with the company's registrations with the USPTO, Patent and Trademark Office. In a 37-page complaint filed Friday in California federal court, Chippendales USA says Jesse Bangery, I think Banerg, Jee. Banerjee, I think maybe Banerjee is the correct, I don't know, maybe, has been claiming to be the eldest son of Chippendales founder Steve Banerjee, saying that he was robbed of his rightful inheritance to the brand, trademark, and royalties. But Steve Banerjee, founder of Chippendales, was arrested in 1993 for multiple crimes, including plotting the murder of his business partner. He had transferred the interest of the company and trademarks to his wife, Irene, before his death in 1994. So not only is there a literal arrest for a murder for hire plot, but there's a transfer of interest. So he transferred the interest to his wife, Irene, before his death in 1994. The company assets were later sold to CLP Tour Limited, which in 2000 sold the business to Chippendales USA Inc. So the owner, founder of Chippendales, transferred his rights in the property to his wife. She sold them to another company. It was like, cash out, we're done, right? And then that company sold it to a third company. So now the heir to the Chippendales pelvic thrusting oiled legacy is saying that he has the rights to the trademarks and the brand. So the plotting murder seems to be the founder of Chippendales, not the son. So the son is saying, no, that was an illegal transfer. So Jesse, the son, has been making claims in his book, Courts. There's a book? I need to make a note. We might need to start a Law Nerds book club. What is the book? Jesse, what is it? Banerjee book. I need to look that up. Oh, I'll share my screen when I pull up the complaint. I'm not at the complaint yet. There's a book. Wait, there's a documentary? What? Oh, I'm in. So he claimed in his book and at the USPTO that the transfer of ownership was illegal. He also continued to interfere with the registered trademarks by making unauthorized filings and attempting to change trademark ownership information. Quote, defendants' unauthorized filings caused the U.S. Patent and Trademark Office to change many of the records for plaintiffs' Chippendales registrations to inaccurately identify his company as the owner, causing plaintiffs significant concern. It's like quitclaim deeding intellectual property. Chippendales is seeking declaratory relief to settle this controversy. Right. So there is a murderous conspiracy, maybe an illegal transfer, and a fight at the trademark office, but it seems like trademark squatting too, because if you're filing all this stuff, you can actually, the way you can mess up like title of a house, they're messing up who owns the rights to this and licensing rights. And there's a lot of money in trademarks. We're going to look at the complaint. It's not pulled up. We're going to look at the complaint a little bit. So let's go to the complaint. Emily, are you ready to share your complaint? I mean, not 100%, but here we go anyway. We're professionals here. How many times can we whop in one morning? All right. The book title, My Life is Not That Kind of Chipmunk. Not an actual murderous conspiracy, right? I have no idea. I didn't know it existed, but I'm going to go find it. Chippendales USA versus, wait, his name is Jesus? And he goes by Jesse. This is even better. Banerjee, doing business as this company. Declaratory judgment as to plaintiff's ownership rights. This is like family law, but in trademark court. This is going to be interesting. Federal trademark infringement, trademark counterfeiting, federal unfair competition, federal trademark dilution, California trademark dilution, California fair businesses. Plaintiff Chippendales brings this action to stop right now. Thank you very much. To stop defendant from continuing to infringe and misuse plaintiff's famous Chippendales trademarks and put an end to defendant's illegal interference with plaintiff's validly held trademark. I feel like I need to go to Chippendales when I'm in Vegas for business purposes during BravoCon. I feel like that's the time. Yep. I feel like that's the time. Despite plaintiff's bona fide acquisition of Chippendales business and Chippendales trademarks over 20 years ago, defendant has repeatedly filed unauthorized documents with the USPTO trying to change ownership of plaintiff's registrations. He's also repeatedly makes public claims in court filings. There's more filings. I need a rabbit hole alert. I don't know what it is. Like rabbit hole alert. Like what? How many filings? What? How long has this been going on in court? Amy Kimball, yes, it would absolutely be a business expense. I would absolutely expense a trip to Chippendales. It's research. I need to see how they're using their trademarks. Where are the trademarks placed? How prevalent are they throughout the show? I need to know. That's a whole nother conversation. It seems like there might be stacks of filings. Wait, is there a Netflix film about this? I need to go find it. I mean, after Vanderpump. I need to know. He also repeatedly makes public claims in court filings with the USPTO and elsewhere that the 1994 sale of the Chippendales business and trademarks was fraudulent, and therefore the subsequent sale of the Chippendales trademark to plaintiff in 2000 was fraudulent, and thus plaintiff is not the legitimate owner. Defendant claims to be the heir of Chippendales founder and alleges that he was robbed of his rightful inheritance. Oh my. Defendant's conduct casts a serious cloud on plaintiff's interest in the world-famous Chippendales brand that it has spent the last 23 years building. That could be a problem for investors, for expansion, for licensing the franchise. If you need like Chippendales Vegas, Chippendales Australia, Chippendales London, Chippendales of TikTok, whatever it is, you need your trademarks to be clear so you can license them. Let's see. Jesse lives in Los Angeles. Plaintiff owns and operates the world-famous Chippendales entertainment brand that produces Broadway-style burlesque shows worldwide. I mean, it's a pretty solid definition. Defendant holds himself out as a representative of an inactive business entity. Okay. California Secretary of State records show that Steve filed articles of incorporation for a stock corporation named, I have no idea how to pronounce that, but E Enterprises on August 29th, 1975. That is currently inactive because it was suspended by the Secretary of State in 2006 and by the Franchise Tax Board in 2007. Well, it seems like somebody's not filing their corporate paperwork. Accordingly, they've lost their rights privileges to do business in California. That's true. But that's from like 2006 and 2007. This is years ago. Oh, Steve is not his real name. Steve is his nickname. California Secretary of State's records show defendant filed articles of incorporation for a separate stock corporation with the same name in 2017. Well, why not just keep the... Okay. This is not your case, Emily. I wanted to know this. History of the Chippendales brand. Yes, stage name. Correct. Stage name. Chippendales is one of the world's most recognizable brand names, providing entertainment for women. I mean, not just women, but okay. Producing Broadway-style burlesque shows worldwide for the ultimate girls' night out. The Chippendales Performance Troupe, this is a lawsuit, these are not my opinions. The Chippendales Performance Troupe was established in Los Angeles in 1979 as the world's first all-male Las Vegas-style dance act. From its founding through today, Chippendales dancers have been immediately recognizable by their cuffs and collars. By the Saturday Night Live skit. which most of you probably know what I'm talking about. Bow tie, white wrist cuffs worn on an otherwise bare torso. Soon after Chippendales was created, it became a cultural phenomenon, which quickly led to the opening of another club in New York City. New York City! Clubs in Dallas, Denver, and touring troops performing in the U.S. and overseas. The revue's popularity also spawned a vast array of licensed merchandise, such as a wildly popular annual calendars and apparel. Are there also sex toys? There need to be sex toys, right? You need like little cuffs and stuff. I can see all of it. Yes, with Patrick Swayze and Chris Farley. It is one of the best SNL skits of all time. Like, Dick in a Box is great. Van Down by the River is great, but nothing is quite as good. God, Chris Farley is so good, but nothing is quite as good as Chippendales. Nothing. Yes, when SNL was funny. Exactly. It is a classic. If you have not seen it, find it on YouTube. It is. Oh, Cowbell's also, more Cowbell's also good. We're going to devolve into debating when SNL was actually funny. More Cowbells in the top 5 with these. Also, I would hasten to say that the Chippendales-esque dance from The Proposal with Sandra Bullock, also 10/10 would recommend, because that movie is fucking hilarious. Okay. Today, the Chippendales Burlesque show continues to entertain sold-out audience from its flagship location at the Chippendales Theater inside the Rio Hotel and Casino, as well as at U.S. and international venues visited by its touring productions. Annually, Chippendales productions are seen by over 2 million people worldwide. Can you tell me how much money it makes? Because I'm just nosy and curious. Plaintiff brought the Chippendales. Bring the Chippendales to Vegas in 2002, where it has delighted audiences for more than 20 years. Las Vegas Chippendales has featured guest hosts such as international supermodel Tyson Beckford, that I would have gone to see, Ian Ziering, Joey Lawrence, Dancing with the Stars, and America's Next Model champion Niall DeMarco. The show had continuously won Las Vegas Review Journal annual awards for Best Male Review and Best Bachelorette Party. Well, obviously they need one in Nashville because this is apparently one of the bachelorette party hubs of the world. Plaintiff is the third owner of the Chippendales business, which it acquired in 2000. It's been a while. The famous trademarks. So they've got trademarks for Chippendales, the name, in a bunch of different categories. This is how trademarks work. You have them in all, you have to trademark it in all the different categories. It has the bow tie design trademarked for electric massage. I was wondering. We've turned into a Ringo episode. Here we go. Chippendales for electronic massage applicants, namely electronic vibrating massagers. There they are. There's the trademarks. The bow tie design for electronic massage appliances. This is probably appliances, not applicants. Namely electronic vibrating massagers, calendars, barware, namely shot glasses, clothing, namely headwear, hats, tank tops, t-shirts. There it was. We knew it was in here somewhere. We knew it was going to be in here somewhere, right? You can't be Chippendales and not have your trademarks protected in the categories for sex toys, right? So then they're going through that these are the registrations. Timeline of Chippendales ownership. This I'm curious about. Steve founded Chippendales in 1979. Upon information and belief, Steve owned and operated the business through that other company, Easby Enterprises, DBA Chippendales, which according to records of the California Secretary of State was incorporated in 1975. That company owned the rights. In September 1973, Steve was arrested for multiple criminal acts and incarcerated. Was he convicted? Because the incarcerated leads me to believe it was more than an arrest, but now I have questions. According to evidence and testimony presented in prior court proceedings involving Steve and his wife Irene, at the time of Steve's arrest, he was president and sole shareholder of the company. That evidence and testimony disclosed that Steve transferred all of his shares to Irene in 1994, which ultimately was reflected in a stipulated judgment of divorce. So they're going to have to go to the divorce filings to prove this up in court. What a mess. Gracie brought up a good point. We might need to vis-a-vis Chippendales versus Thunder from Down Under. We might need to just evaluate both. We might need to evaluate both. All right. The judge's name is Macbeth? Come on. You're fucking with me now. He gets arrested and seemingly incarcerated for a murderous conspiracy. He transfers all of his shares in the company to his wife, Irene, who divorces him. And the divorce judge's name is Macbeth? Come on. I love court so much. I was not expecting that. This is why we go to the filings. This is why you go to the filings. So far, we have an heir battling for his rights to the male dancers. We have trademarks for vibrators, and we have a judge named Macbeth. I'm delighted. Okay. So they're going to have to go back to the divorce decree to prove that there was a legitimate transfer here, but that's not hard to do. You've got a court filing, and Judge Macbeth is like, out. That wasn't Macbeth who said it. I know. It was Lady Macbeth who said it, but just go with it. It's been a really long time since I've studied Shakespeare. Rachie said, Emily, we need to follow this one. Oh, yes. Oh, this is getting added to the docket immediately. Immediately. Wait, Nothing is real in 2023. Yep. Shakespeare wasn't on my bingo card either. And I'm here for it. You know, Shakespeare loved the good interfamilial drama. Oh, the irony on this is so good. It's so the Honorable Hugh E. Macbeth. Somebody name a character in a book Hugh E. Macbeth, please. So this is the divorce decree from 1994 that divided the marital property and provided for family support. Was the kid who's claiming to be the heir provided for was the familial support for this kid who's saying that they're the heir? Or is this kid pretending to be the heir? Is he really the heir? Now I have questions about that. A copy of that judgment is signed by Steve and Irene, attached as Exhibit 2. On October 23rd, 1994, Steve died while incarcerated in Los Angeles. Huh. How long after the transfer in 1994? Not long. The divorce was decreed on August 17th, 1994, and he passed in custody in October 1994. I have questions. I have questions. Okay. So then the company sells Chippendales to another company in November 1994. So he dies in custody October 23rd, 1994, and his ex sells the company the next month? How do you even have time to negotiate a sale? Oh, thanks, chat, for clearing that up. I knew none of this. So he didn't go to trial. Okay. I need to watch, apparently I need to watch the documentary. Okay. He was in jail for a murderous conspiracy of killing his business partner, but if he was in control of the timing of his own death, then it makes more sense that the death happened in such quick succession to the divorce. Like the two things don't seem incoincidental. Thanks, chat. I appreciate it. Okay. The layers of this story I was not anticipating. Nope. I just saw Chippendales and I went, I'm in. Chippendales trademark dispute, I'm in. The amount of drama under this trademark dispute is yeah. It's quite a lot. Okay. So in November, the wife or the ex-wife sold the company to another company. And then you transfer the trademarks. And then it continues to operate. CLP continued to operate the Chippendales business and trademarks until it sold the business to plaintiff that's bringing this action in 2000. Irene passed away in 2001. And then after that, the company was suspended, right? Because nobody was filing documents. And after she passed away, people probably forgot to actually wrap up the corporation because everything had been sold. That makes more sense. Defendant's litigation filings, unauthorized PTO filings, and infringement. Defendant has no rights to the Chippendales mark. Defendant has no rights in the entity, which was originally owned by Steve and later owned by Irene. Defendant has claimed in another tribunal and before the USPTO, as well in his books he has published in various online channels, that he is the oldest son of Steve and that he was swindled out of his rightful inheritance upon Steve's death because the Chippendales trademark was fraudulently sold and fraudulently transferred. It sounds like the divorce court did it. Footnote 1. Although defendant has alleged in probate filings and USPTO filings that the November 1994 sale of the singular Chippendales trademark was fraudulent. At the time, the Chippendales business used and owned common law rights in the wordmark Chippendales. As well as stylized Chippendales logo with design for a variety of goods. This is going to be more complicated than it should be. As detailed below, defendant has asked LA County Superior Court and the USPTO to hold the Chippendales trademark is owned by his company and or Steve's estate, footnotes 2 and 3. This litigation has tentacles. So why is this in federal court now? This has been going on since 2016. Yikes. The amount of money they must be spending to fight with this. That's why they're in federal court now to kind of final order. I'm going to have to pull up the probate filings and see what we can find. I feel like I need to read the book too. Defendant's book claiming ownership of the Chippendales trademarks December 2021 and June 2022. In December 2021, defendant self-published. Are they taking a dig at self-publishing or just making it clear? Defendant self-published a book titled Bowtie Legacy, detailing his claims that he was swindled out of his rightful inheritance because of the 1994 sale of the trademarks. In June 2022, defendant self-published a book titled Chippendales True Crime Story with identical content as Bowtie Legacy. Wait. He republished a second book and just changed the title and the cover. So he changed the title and the thumbnail to try to get more traction. Is he also a YouTuber? These are YouTube tactics. Change the title, see if it gets more reach. So we thought by adding the name True Crime, it was going to get more traction. Maybe it did. Identical content as Bowtie Legacy, same allegations, just packaged under a different name and front cover. YouTube tricks of the trade. In defendant's books that normally I don't engage in, it's like, change the thumbnail, it might get more reach. I'm like, I stream again on Thursday. It'll be fine. He asserts that being named administrator of the estate meant that he would own or control all the Chippendales assets. No, because in the divorce, it went to Irene. The estate doesn't own it. The court finally declared me the administrator of the Banerjee estate 26 years after Steve's death. Now, the corporation that owns all of the properties, including but not limited to the dance troupe, television, movie rights, and merchandising, was back in the hands of Banerjee. This sounds like it's from the book. This is not accurate. In the chat, did Irene die? Yes, Irene passed in 2001, it says. In late 2022 and early 2023, defendant continued to interfere with the registered trademarks, making several unauthorized filings regarding the USPTO trademarks, and then it listed the trademark names. Defendant listed his new company as the owner in the filings and signed the forms as a state administrator, listing his personal mailing and email address. This is going to be a mess. This is like trademark squatting. It's wild. On December 28, 2022, defendant attempted to file a purported specimen for use. Chippendales Mail Review by the creator's first son. Are there other kids? What do they think? I need to know everything. A new generation of entertainment, fashion shows, country events, fair shows, and brand ambassadors. The attached specimen was in use in commerce before the filing date of the request. Oh, this is a mess. Defendant initiates an independent civil action against plaintiff through a petition filed in the probate action in April 2023. Oh, I need to go find that. Y'all, we're going to have to do a deeper dive on this. We need to have more of a conversation. What was filed in the probate court in April? That's last month. Okay. April 3rd, 2023, defendant filed in the probate action a petition titled Petition for an Order Confirming USPTO Decision on Chippendales Trademark for all series pertaining to Chippendales as forming part of the estate of Steve Banerjee, requesting Section 859 double damages against Chippendales USA LLC, footnote 4. The document's footer identifies the filing as petition to confirm assets of the estate. Who's the attorney representing him in this? I'm so curious. The petition was filed pursuant to California Probate Code 850, 859. 850A3B allows a trustee or any interested person to seek a court order declaring that a trustee's interest in real or personal property, title to or possession of which is held by another. Oh. Defendant alleges that Chippendales trademark was an asset of Steve when he passed in 1994 and was worth $50 million, and that year it was fraudulently sold by Irene for $1 million. If the divorce court gave that property to Irene, then it's not fraudulent. Is this, I have more questions. Is this a second wife? Is this like a stepmom? Or is this his mom? Is this a fight between like this surviving son and his mom? Or is this stepmom and him? Wait, did somebody in the chat just say 12th wife? You're joking with me, right? That is a joke. We are being hyperbolic. I'm going to have to deep dive onto this. We're going to look more into this on Thursday. Maybe I'll have some questions because we would see fraudulent transfers argued like this in probate court. I mean, this kind of shit happens in probate court, argued more, not between like subsequent spouses, like when you get, I don't know, kind of like the Anna Nicole Smith fight, right? You get the kids saying, no, this subsequent spouse doesn't get this property. That goes to the kids. You can see it in those circumstances. So I need to do a deep dive into this. Are there stacks of wives? Art by Julie said, I need a string graph right. Nikki, it happens. It's tragic. It does happen. I don't know if that's the circumstance here. But now I need to know. Apparently, I need to watch the documentary and Vanderpump. Okay. Oh God, there's pictures. Look, as much as I love the articles that summarize these lawsuits, the lawsuits when they contain pictures are my fucking favorite. Lawyers. Look, I'm a simple girl. I'm just a streamer who has been a lawyer for a real long time. I am now entertained more because there's pictures. Okay, let's get back to the pictures. Sorry. I don't know what value these have. Why are there pictures? Defendant's infringement of the Chippendales trademarks. Upon information and belief, sometime during July 2022, defendant launched a website called chippendalestruecrime.com. Oh, don't worry. We'll look at the pictures in a second. We love pictures and sassy footnotes. Yes. CJ Drake, these are things I don't share with the internet. Streamer. And it has to depend otherwise. Upon information and belief, sometime during July 2022, defendant launched a website, chippendalestruecrime.com. The top of defendant's website prominently displays the Chippendales mark as well as the unauthorized use of plaintiff's Chippendales bow tie design. Moreover, defendant's website has even copied the color scheme, layout, and design features of plaintiff's website. Oh, God. Chippendales.com. Oh, we're getting a juxtaposition of Chippendales. Who's Vinny G? Vinny G returns August 31st through October 8th. All right. This is the Chippendales website. They have a recruitment section. Limited engagement with Vinny G in Vegas. Chippendales True Crime. It is the bow tie logo. Wait, no, not Vinny from Jersey Shore. Wait, really? Brian, I'm going to Vegas. Stop it. This is where we have a Law Nerd meetup. Wait, is Vinny? Wait, we're going to the website. Hold on. I am dying. Okay. Yep. That's absolutely Vinny from Jersey Shore. Vinny from Jersey Shore is performing with Chippendales in Vegas.
Were you screaming at me that you were going to Vegas to see Vinny from the Jersey Shore perform with Chippendales?
Yes. That's Vinny. That's Vinny from Jersey Shore.
That doesn't look like Vinny.
That's Vinny. Look, it's been a long time since we've caught up on Jersey Shore. So Vinny G returns August 31st through October 8th. There's still time. But not there during BravoCon. Vinny, extend the review to BravoCon.
GTL, baby.
I love you, hon. I'm going to tell you all about this filing when we're done. Okay. Yes. Vinny is back. That looks like Vinny. Vinny is back at Chippendales. All right. I didn't know we were selling Chippendales today, but look, get your lip glosses to take with you to Chippendales. He does a whole I am shook. Oh, the amount of time I'm going to end up in Vegas. Brandy, that's what we're here for. Sometimes law is too serious. This lawsuit has pictures. We can't take things too seriously. I love that the lawsuit is advertising that Vinny G is returning. I love this lawsuit so much. It's not what I expected. This is not what I was expecting. All right. Defendant's website. Who am I? Price plans. Oh, there's a membership tier, registration, free content, login and sign up. True crime, stolen inheritance, complicity, New York organized crime, deceit, and fraud. Is this a tagline, or is this somebody just dumping all their keywords to try to boost their SEO? I feel like this is just a keyword dump. But anyway, does his tattoo say GTL? I have no idea, but I hope so. Chat, I just hope so at this point. I haven't investigated enough. Look, I love Jersey Shore. I need to catch up on Family Vacation. I might need to do a rewatch. I need Vinny to still be there in November for BravoCon. I don't know if I can get to Vegas twice between now and November with all my other travel. Maybe. This lawsuit has everything. I had look, between Judge Macbeth and the Jersey Shore connection, this lawsuit is giving. It's just giving everything. We needed a giggle. Here it is. I am shook. How old is Vinny? Like, you go, Vinny. Look, get it. I love the amount of you in the chat that are like, I've seen him live. Emily, did you not know about the background? No idea. No idea. Kim, this is incredibly kind and thoughtful. Thank you. You know what happens when I go to Vegas. Here's the thing. Look, I saw the headlines and I went, okay. Chippendales trademark suit. This will be interesting. And then as we got into it today, this is why I do first looks with you. When I got into it today, I went, what the fuck? So that's how our quick bits ended up not being so quick today. Further, defendant's website at Chippendale True Crime offers and sells apparel, mobile phone cases, and mugs bearing the mark Chippendale's True Crime Story with the bow tie design. Oh, that's going to be a problem. That's a problem. No. Okay, this is Chippendale's actual stuff. This is plaintiff's authentic merchandise. This is defendant's merchandise. Okay. Yeah. All right. There's hoodies. Wait, where did they source these mugs? I like the mugs. Whoever's doing merch for Chippendales, I doubt that you're watching, but the mugs are fire. I like those. I like the tall mugs. I need to find some tall mugs. Okay. Wait, what is happening? Defendant advertises himself and his services. What services? I don't want to know. Do I know? I don't. Okay. Defendant advertises himself and his services using the mark Chippendales Air on multiple social media platforms and commercial websites. Twitter, Jesse Chippendale's first son, an estate admin. So they're saying he's now using the trademark in a way that he's not allowed to. Oh my. Instagram, Posh Agency live show. What is happening? LinkedIn. Defendant also advertises himself and his services under other infringing marks such as Chippendales Estate Administrator, Chippendales Authority, and even misrepresents himself as Chippendales Chief Legal Strategist. What the fuck? Strategic administrator of the world name trademark. That's not even a real sentence. Chippendales chief legal strategist on LinkedIn. That's interesting. This is interesting. They want declaratory judgment. We're not done. We're not done. Maybe we need to go research the Beaver Moon in Vegas at Chippendales and yell GTL at Vinny. There's a book. There's apparently a documentary. There's a real interesting lawsuit. There's an estate lawsuit. Oh boy. Beach, please. I let you know about the impulsivity. The fact that I have not yet booked tickets just tells you how busy my calendar is. That tells you how busy my calendar is, that I have not actually booked tickets to go to Vegas in like September. Y'all know I have ADHD. We're going to the website. I'm going to Vegas. Yes. Impulsivity. Or impulsivity. Okay. We need to cover Kohberger. There is a TikTok lawsuit that I'm just going to bump to Thursday because we have a ton of Kohberger stuff to cover. And it's going to be a transition from the ridiculousness of whatever the fuck this is with Chippendales, the way I had no idea what I had waded into. And now I'm just like, I just want to binge watch Jersey Shore while I play Zelda. I will tell you, I had famous people show up at my courthouse. I was involved in cases involving celebrities. And there was a member that popped into my jury panel that I was just like geeked about. And I'm like, I want to talk to this juror so badly. And that's the thing. You can't really talk to jurors. So I'm interested in people. I like people. I like hearing their stories. I like knowing about your life. I'm fascinated. This is when people ask me like, what is the type of stuff you watch on YouTube? When it's not watching my friends who are covering like drama commentary or in the true crime space, I watch a lot of slice of life, or at least that's what I would call it, content. Someone who's living abroad for college, someone who lives in the northernmost town in the fucking world and is like, this is how I live literally basically at the North Pole. This is what our town's like. This is how we live. Fascinated by people's lives. So there was a juror that popped up that worked production for Jersey Shore, and I was basically sitting on my hands because all I wanted to do was be like, oh my God, tell me everything. Did all of production die when Snooki showed up with trash bags carrying her clothes? Like, I want to know everything. Tell me everything, which is what I loved about living outside of Los Angeles. Is so many of the people that lived in the communities I lived in worked in the film and television industry, worked production, worked as PAs, worked in sound and costuming and hair and makeup. They have all of the fucking tea. All of it. And it was delightful. I'm like, tell me more about that. Everything. I want to know everything. What is filming on that show like? What is filming with that family like? As production, how often is your phone ringing in the middle of the night to deal with shit that's not really production related? Come on, tell me. Are you the fixer? I want to know. A lot of times production is the fixer. Shocking. Emily, I used to live in New Jersey and down the Jersey Shore. I was on the boardwalk. I'm fascinated. I used to visit the Jersey Shore when I was growing up, but we didn't visit that part of the Jersey Shore. We visited the dry part of the Jersey Shore. Good donuts in Ocean City, I gotta say. My parents met working at the Jersey Shore, but we were not at the seaside part of the Jersey Shore. All right. We have now an hour in and we need to get to Idaho. So we need to just, I don't know. We need palate cleansing music. Let's take a stretch. Y'all hydrate, take a stretch. We're going to have to shift. We're going to have to shift to heavier topics. All right. And then we'll swoop. After we're done, we'll swoop. And I'm going to make sure there's nothing else. We're going to look for some new documents real quick while we're stretching. I'm going to make sure there's nothing new today. Because I checked yesterday. That doesn't mean there's not something new today. There was new stuff yesterday, and that's what we're talking about today, mostly. Let's go look at the TikTok suit real quick, because sometimes we're gonna end up, the mods are like, please don't look for new documents. We're already behind. We're already behind. Yes, we are. But that's okay. What's behind, really? It's all streaming time. There's new documents today in the TikTok defamation case. Do we save those for last? That was filed this morning. Do we save that for last? We save that for last, right? Okay, let's do our other Kohberger stuff and then we'll do TikTok defamation stuff. New documents in the TikTok case. Those were filed this morning. God, this is why I stream this time of day, because time is a construct. Okay. So we're going to cover the Kohberger filings from yesterday. And then we're going to cover the new stuff in the TikTok defamation case with regard to Idaho. Okay. That's the plan for the rest of the show. And then we will get to Q&As. All right. New filings in the Idaho college murders and new filings in the TikTok defamation case. Everything will be time stamped below. Let's start with what is new in the King Road case. So we have been covering all of the back and forth with regard to the non-dissemination order or the gag order. Yesterday, I saw and these were really from like the 12th, the state's response. They just popped up on the website though. We've got an objection. Let me do a quick road so far with the gag order only. The court did an amended non-dissemination or a gag order. The media outlets and lawyer representing one of the victims' families appealed that to the state Supreme Court. The state Supreme Court said, hey, go talk to the judge that ordered it first. So then they filed their motions. Well, the media filed their motion in local court. The family had already filed their motion in local court. And the gag order had just been done in one day on stipulation between the defense and the prosecution. So now we are pending a scheduling hearing next week. I will stream the scheduling hearing. It'll probably be pretty quick. We'll stream the scheduling hearing next week. The scheduling hearing is going to set a date for this to be argued. The media I covered last week saying, hey, we have a First Amendment right to access this. And with the balancing test, here's how we balance the rights of the media and a free press and the rights of the defendant. What is the least restrictive means here? And they gave a bunch of case law saying, hey, there's different ways to get to least restrictive means, but this fucking gag order ain't it. I'm summarizing. That's not what their filing says. Somebody's going to be new here and be like, their filing said that. No, I said that. Their filing said that in a much more lawyerly way. I translate lawyerly into cursey words. So Brian Kohberger objected to that motion that I covered last week. We're going to look at his objection. Then we're going to look at the media's response. Then we're going to look at the state's response to all the discovery. Remember the discovery where we learned for the first time that Kohberger was interrogated by police? All that was in the new discovery orders. Let's go to Kohberger's objection to the motion to vacate first, then the response to it. And this is only a 3-page motion, so we're going to get through these pretty quickly before we get to the TikTok defamation case. Okay. Hold on. I'm going to do that. And let us ride. All right. Objection to motion to reconsider. Ashley, I'm going to pull this up when we get to questions and talk about it for sure. Comes now. Brian C. Kohberger, by and through his attorney. This is the new attorney. J. Weston Logsden, Chief Deputy of Litigation. This is a new public defender that has been added to the team. Ann Taylor, J. Weston Logsden, and Elisa Masseroth. So this, based on bar number, the chief deputy of litigation is one of the newer attorneys to the group. And you can tell because the bar numbers here are 5836 and 5647. So this is the most senior with the lowest bar number. This is the most junior with the highest bar number. Those bar numbers are still real low compared to states like California, but different states, different amount of lawyers, right? So this is the new defense attorneys that's been added. The media argues in its motion that it is irreparably harmed each day this court's amended non-dissemination order remains in place. The media is watching the money fly out the door, right? In essence, the media argues that this court should grant a temporary injunction against its own injunction. That's not really what they're arguing. They're arguing to vacate it. They're like, yeet. They're arguing that the court set it aside. They didn't even really argue for the court to modify it, though I think that might work. They're saying that it is too restrictive and the court needs to get rid of it entirely. It claims that this was the intent of the Supreme Court because it moved quickly to determine that its petition for a writ was filed in the wrong form and using the wrong vehicle. What the media fails to note is that the Supreme Court provided no such directive in its written decision. I think that's open for interpretation, but okay. It also fails to note that the petition for a writ was a purely legal issue, whereas as it why are we using whereas then as? As it has repeatedly argued, the basis for the entry or amendment of a non-dissemination order is a question of law and fact. I agree with that. The media seems to be acting on the premise that the order should simply vanish now that it has arrived on the scene. No. They're arguing that their right to a free press is being infringed by an overly restrictive gag order, and that the gag order is not the least restrictive means. That's what they're arguing. They're not arguing that they're like, we are the media. They're arguing that they had the right to be heard before it was just handed down. But okay. I mean, again, this is the advocacy writing. So it's breaking it down in their framing. Instead, this court has reasonably and correctly recognized, oh, wise court so wise. The court is so wise. Always a good thing. Always a good thing. If you can compliment the court, compliment the court. Don't tell the court that they're hydrated and looking snatched and that their eyebrows are on point. They don't always appreciate that. But, oh, wise court, as the court has so astutely noted. You know who's great at this? Britney Spears' attorney is great at this. Benjamin Chu is great at this. As the court has so wisely and correctly ruled, blah, 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 blah. Oh, wise court. So pretty. So smart. Instead, this court has reasonably and correctly recognized that the proper path forward is a hearing where the parties may show what evidence there is of prejudice and the potential for prejudice. That's correct. There should be a hearing. Agreed. Because the media coverage of this case has been intense, I mean, it's been less intense, I think, because of the non-dissemination order. You let me know what you think. Because the media coverage of this case has been intense and because Kohberger plans on providing expert testimony on its damaging effects, that's the part I'm interested in. Mr. Kohberger will require additional time and will not be prepared for such hearing on May 22nd. Bro, dude, friend, the May 22nd hearing is a scheduling hearing. It clearly says in the order from the court that it's a scheduling hearing. What part of scheduling hearing means you're supposed to hear it that day? The scheduling hearing is it's a meeting to pick a day for a meeting. No one expects you to be ready on Monday, but I'm real interested when this is going to happen. I will be covering this hearing. If they try to hold this hearing while I'm on a plane, I swear I'm going to be very deeply frustrated, but we'll figure it out. I've changed flights and plans before. I want to hear this hearing. I want to know what expert testimony they have about the damaging effects. What damaging effects? So let's see what the media has to say about all this, shall we? The media responds to Kohberger's objection same day, it seems, because this was filed May 11th at 13:03:04. That's not very late. But the Kohberger objection was filed May 11th at 9:31. How? The fact that they turned around between 9:31 a.m. and 1 o'clock p.m., this response is a swiftness. So here's the media response to it. With a swiftness. Reply to Mr. Kohberger's objection dated May 11th. Also filed on May 11th. These attorneys are like, I got you. We were ready. Mr. Kohberger's objection to intervener's motion to reconsider order. Wait, you called it a motion to vacate order the first time. You can't retitle your order. I was kind of critical. I was like, they didn't even say reconsider. They just said vacate, but okay. Mr. Kohberger's objection to intervener's motion to reconsider order dated May 4th, 2023 highlights the exact problem here. He requested and received a gag order without submitting supporting evidence to the court. He says he now has evidence to support his request for a gag order, but needs time to put it together, even though the gag order has been in place for over 4 months. Well, because you went to the Supreme Court first instead of bringing this motion here. Here's what happened time-wise. The attorney for the Gonsalves family filed in court to reconsider the gag order, but the media filed in the Supreme Court. And so the local court said, I'm going to wait to see what they do. So I'm not going to hear any of this until the higher court rules. So the district court said, I defer to them. That's why it took 4 months. It took 4 months because they chose to go to the Supreme Court first instead of going to the district court first. One can only assume that this was a strategic call by their lawyers. So they chose to go to the Supreme Court first and not the district court. They could have gone to the district court first. I imagine here's what would have happened. They go to the district court and they're like, you didn't hear any evidence on this reconsider, the entire motion we've just seen. And the district court goes, yeah. Here's a hearing, gag order stands. And then they go to the Supreme Court. We probably would find ourselves in the same situation, just in the right order. This went a little out of order. You're out of order. I couldn't out myself. He now says he has evidence to support his request for a gag order, but needs time to put it together. And asked the court to continue to enforce the gag order while he collects his evidence. True. Mr. Kohberger's request turns the judicial process on its head. I mean, that's dramatic. When a party requests a court order, he has the burden of submitting the evidence that supports that order before the court issues the order. But the court didn't do it here. The court went, y'all agree? Great. Fine. I bet you the court was thankful too. This is just my speculation. Look, Emily's speculation. Speculation. I imagine the court doesn't want this kind of invasive media coverage either. Right? And so when the prosecution and the defense were both like, hey, Your Honor, we'd sure love a gag order, the court went, great. Here you go. Everyone agrees. And then the media came in and is like, excuse me, not everyone agrees. We also have rights here. And now they're trying to unwind it. And that's going to take a little bit of effort. What they're arguing is that what should have happened is that the court should have allowed for third parties like the media to be heard before the gag order was issued. Instead, the gag order stands while they try to undo it because the court just went, we're good. We're all good. Don't worry. So there's Kohberger's request now turns the judicial process on its head. When a party requests a court order, they have the burden of submitting the evidence before the order. That didn't happen here. A party is not entitled to obtain relief first and then take months to collect and present evidence. Look, Kohberger's not taking months to present evidence. The months were wasted, not at Kohberger's fault. This is me arguendoing both motions. I argued Kohberger's motion, and I'm going to argue against their motion too. Kohberger didn't take months to gather evidence. You just objected a few weeks ago. You objected to the Supreme Court, and he didn't have to present this type of evidence at the Supreme Court level. He objected there too. A party is not entitled to obtain relief first and then take months to collect evidence. While those principles apply generally to the judicial process, they're paramount when the unsupported court order restricts First Amendment rights. The loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. They want to be able to be running stories on this. Y'all, I'm seeing your comments about buffering. That's not me. So I don't see it on my end. Sorry, y'all. That might have been a YouTube blip. Hopefully it wasn't a me blip, but I see you in the chat. I don't see it on my end. Try restarting YouTube if it's an issue. They go on to say that interveners have suffered irreparable harm to their constitutional rights since January. The judicial process, including the expectation that a party submits evidence before obtaining relief, particularly relief that affects another party, is designed to prevent irreparable harm. As Mr. Kohberger now acknowledges, that process was not followed here, and he still has not even collected the evidence he intends to submit. As interveners have requested, the court should stay enforcement of the amended non-dissemination order pending any further briefing. So they do want the court to pause the non-dissemination order until this can be heard. If indeed an evidentiary hearing is the next step to determine whether a gag order is needed, no gag order should be enforced in advance of that hearing. All right, and then this was sent. Let's see what's going on with discovery. So we have 2 responses for discovery. We're learning a lot more about this case through the discovery motions because the defense has made a motion to compel discovery with regard to mostly the DNA evidence and the defendant's interrogation. Like, yo, we need this information. This preliminary hearing is like a little over a month away. So they're ready for it, right? So, let's look at the state's response to the motion to compel first, and then we'll go to the state's response to the third discovery request second. Let's see what else is going on in discovery in the Kohberger case. I keep forgetting to do this. All right. State's response to defendant's motion to compel discovery. By way of background, as of the date of this response, which is May 12th, as of the date of this response, the state has provided the following discovery to defendant: approximately 10,000 pages of reports and written materials, 10,200 photographs, and approximately 9,200 tips, and approximately 51 terabytes of audio, video, media, and digital materials. Holy shit. 50 terabytes? This trial, if this goes to trial, this is going to last forever. They don't, of course, have to bring all this in. This is a complete just, whew. This is a lot of discovery. So when they're in the motion to compel, they're like, we've turned over discovery. Literally all of it. What? 51 terabytes of audio and video. What is in all of that audio and video? Here's some more Emily speculation, just because I did cases with audio and video. This can be all the surveillance camera video they gathered. This can be interviews. And when I say surveillance, if they have like 3 minutes in a parking lot, but they pulled the whole video, they probably included and should include the entirety of the video. So surveillance videos, we know there's videos of what the police suspect and allege to be Kohberger's car at different locations. We know that they grabbed video from places where the victims were that evening. So surveillance videos, interview videos, all that kind of stuff. And this can also be videos of the scientific data that's being turned over, cell phone dumps and data dumps from computers and things like that. With the above in mind, the state respectfully submits the following specific responses to items 1 through 6. The state has disclosed all items it is aware of relating to the search and arrest of Kohberger in Pennsylvania. The state is unaware of any body cam and dash cam footage beyond what has been disclosed. So that cam footage is also going to be in those terabytes of data. So if it's already been turned over, what does the defense think they're going to get more? The state is unaware of any body cam or dash cam footage beyond what's been disclosed. On information and belief, understands there is no body cam footage. So now we've heard there might be body cam footage in Pennsylvania from the defense motion, and the prosecution's coming in and saying, it's our understanding that there is none. Recordings of interviews and the defendant's transport from the scene of the arrest have been provided. Numerous lab reports regarding forensic evidence collection and analysis of items recovered from defendants' parents' homes, trash cans, and other receptacles, defendants' vehicles, have been disclosed to the defendant. Those reports include items from the FBI laboratory in Quantico, Virginia, as well as the Idaho State Police Lab. The defendant's attorneys and investigators were also given direct access to view and inspect the items seized from his parents' residence, including his vehicle. The state will continue to disclose additional reports as it receives them, subject to their ongoing discovery obligations. To the extent that the defense believes certain reports may contain exculpatory information, the state asks that the defendants specify, they don't know, what exculpatory information they are returning to and the basis for their belief, so as to enable the state to make any appropriate additional inquiries. They're just saying any exculpatory, and the state's like, what are you looking for? Regarding the defendant's request labeled 2A, in addition to the above response, the state has inquired of the defense for clarification on ISP lab reports by number, since there is a question about some duplicate numbering of initial lab reports. ISP lab reports are separately numbered by forensic biology, DNA prints, and forensic field services. The state has already been able to advise defense counsel that there is an ISP lab report 25, which has been discovered, and there is another ISP lab report 11, which is pending review and approval. Okay. The state has provided recordings of MPD Detective Payne's interview with Mr. Kohberger to the defense. When? Was it after the motion came in? So we now know there was at least some interview or interrogation of the defendant. The state will provide any related reports or notes as they are received, reviewed. As with item number 1 above, the state has provided the defense with reports, audio, video, and other recordings relating to the defendant's arrest and incarceration in Pennsylvania that have been received by the state. So we've given you what we have. The state has provided a copy of the report memo referred to as request number 161 to the defendant. The state is unaware of any notes, recordings, or photographs. Here's the thing the state's obligated to do. Even if the state hasn't seen it and doesn't know its exist or doesn't know of its existence or whether or not it exists, they have to go to law enforcement and be like, are you sure we have every report? Which can be exhausting because sometimes your investigating officer is like, yep, you sure do. And then you're in trial and there's another report and you're like, the fuck is this? I asked you for everything. There are times I have sat down with law enforcement and defense with all of our discovery books and gone page by page to make sure that everyone has everything. And I've gone to labs to be like, are there any more reports? But this is something that the prosecution, it is a very large part of their job, is making sure that even if they don't, they're responsible for it, even if they don't know it exists, they have to get it from all law enforcement. And that can be difficult multi-jurisdictionally. But law enforcement also knows, or should know, the importance of this, because if they don't turn things over, it's a problem. So, it seems that the prosecution has turned this over. It's just when. Did they turn it over after the motion to compel? Or not? The state respectfully submits that training records of specific officers are outside the scope, and I said that when I went over the other one that they probably are. The court will have to litigate that dispute. So, let's see. Somebody said that sounds like a big headache. Laura, the obligations of the prosecution to make sure, these are your Brady obligations, to make sure that everything is turned over to the defense are the only way to protect a conviction. Because if you get a conviction on someone, that, especially in a case like this, right? If we're assuming that the prosecution would not have brought this case against Brian Kohberger unless they believed that they could prove beyond a reasonable doubt he's the one that did this. So if you have a quadruple homicide, you have 4 victims' families, friends, college community that deserve answers and deserve justice. And if your prosecution gets fucked up because somebody didn't turn over a report, it is completely unacceptable. And the defense has an absolute right to those documents. So you have to go and find all of those reports. And it doesn't matter as the prosecutor if you don't know they exist. You are obligated to turn them over, whether you've ever seen them or not. And that is one of the most important parts, I think, personal opinion, of a prosecutor's job, is to make sure that the defense has everything that they're supposed to have. And that is really one of the number one things that has to be done. And discovery fights can get real petty. And defense attorneys can try to bury the prosecution in paper. But also, if the defense didn't have the defendant's interview on video, they need to have it, right? Turn it over. The prosecution has it. You know they reviewed it before filing. Turn it over in the initial discovery. There shouldn't be hiding the ball with these things. There shouldn't be fuckery in the discovery process. That happens more in civil. In civil, it becomes a tactic, but it's different. The rights you're dealing with at civil are different. You're not prosecuting someone where they can face the death penalty. There's no fuck around in that. All right, let's go. So it's a ton of work. But good prosecutors are like, this is what it is. Does Idaho have the death penalty? Yes. And they do. All right. Mimi reminded the chat that's how Lori Vallow's lawyers got death penalty off the table. Well, technically the court did it, but yes, it was a discovery sanction because the prosecutors hadn't turned over everything. And they said, fine, you're not meeting your discovery obligations. That's it. I don't think there's been a determination yet with regard to Kohberger. It's too early for that determination. They're going to get through the prelim first. So we'll see. All right. Let's continue on. For the second discovery motion, because the state responded twice. And then we're going to the defamation case. State's response to defendant's third supplemental request for discovery. This is probably going to be more of the same. Let's see. In regards to standard lab discovery, the state has already provided the defense with everything it's received from the FBI lab. The state also provided the defense with approximately 30 reports from the Idaho State Lab. That's a lot, but I'm not surprised in a case with this many victims. My in-ears just fell, and now I'm like being dragged down from the ear. All right. Let's see. Whitney, this is a great question. I'm going to save it till Q&A. The state specifically objects to the request for personnel-related information as it's outside the scope. That'll be determined by the court. In regards to the defense's request, and there's time for this stuff to be done. In regard to the defense's request for genetic genealogy testing and search, the state objects and intends to separately file a motion in limine, a motion for protective order. Okay, so there's some discovery fights that are going to happen with regard to what they were looking at. As will be more fully detailed in said motion, the state believes that the defense requested discoveries outside the scope of what they're required to turn over, and it does not tend to negate the guilt of the accused as to the offense charged or tend to reduce punishment for offenses as contemplated by the Idaho Criminal Rules 16A, and is not relevant. It is not material to the preparation of the defense. Well, you don't get to decide that, but that's what the law says. It is not intended for use by the state at trial. So they're going to have motions over that, which is fair to say, look, we're not using this in the prosecution, so we're going to have to do motions. If the court wants us to turn it over, they're going to have to demand that we turn it over. So with all this, the preliminary hearing is set to go forward the last week of June. I will be covering it. From there, we will see if the defendant waives his right to a speedy trial or not. If he waives his right to a speedy trial, this trial could be a year or more out. If he does not waive his right to a speedy trial, then we could see this trial much sooner than that. So we'll know more after the prelim. So I'm not going to speculate too much on it until we get to the preliminary hearing. But if he waives time, we could be a year or more, and his defense might want to waive time considering other high-profile cases going on in Idaho, considering... Why is my device trying to listen to me? Stop it. Considering other high-profile cases going on in Idaho, considering the media attention, they... Sorry, I needed to yell at my S-word device. It's like playing music. Stop it! Rude. So they might want to waive time to allow some time to pass and allow the interest to die down. I don't think it will, though. I don't think that'll help, truly. So that's everything that's going on right now in the criminal case in Idaho. We have some fights going on with the discovery that's going to heat up, but the prosecution has said, look, we've turned over everything we're obligated to turn over. As to these specific things, we're not obligated to turn it over. We're going to have to do motions on it. And then we've still got the gag order. The media is like, tick-tock. We want to run stories. We want to talk to people. We want to be covering this day in and day out. And the media doesn't, they don't want to just cover the court filings like I do. I love covering court filings. Court filings have all kinds of interesting shit in them. Because you can't make any of this stuff up. At least I can't. I'm not nearly creative enough to make up the shit that goes on in court. Look, sometimes truth is stranger than fiction. Bad religion. Facts. Speaking of sometimes truth is stranger than fiction, the pro per defendant has answered in the Idaho murders defamation case. Defendant TikToker has filed an answer this morning in the TikTok defamation case. We're going to go over it now. I'm seeing in the chat that today is International Pickle Day. We will pickle later. We will. And I promise after stream, I will put up the pickle poll so we can name the pickle. All right. We're going to do this again just because I love the new bumper that Megalina made so much. When things get filed in the morning, we get to cover them. Okay. This is TikToker versus Professor. Let's do a quick road so far before we get into this brand new filing. With regard to the Idaho University murders, there is a TikToker that was accusing a college professor of hiring and being involved in this murder, that Brian Kohberger, who's been arrested, is not the one who did this, that they know that the professor is involved because they are a spiritual witness. They say it. They'll probably say it again. That they have made tons and tons of TikToks regarding this professor having an inappropriate relationship. This is all based on their own purported psychic ability and their own purported use of tarot cards and other things. I am not going to get into any of that conversation. What I'm going to say is trying to say that I have or an individual saying they have psychic knowledge and that makes it not defamation is not going to work in court if the things are not true. That is not going to fly. And there is no TikToker privilege, which they asserted in their last answer. This answer might be exactly the same. And if it is, then we'll know. But I'm going to zoom past the first page because they are still representing themselves pro se. And they put they put an address on here and a phone number and an email. And I don't want the internet to. Internet. So, introduction. Paragraph 1 of the introduction of the complaint contains a narrative for which no answer is required. We're making a really bold determination there. I don't need to answer. In November 2022, 4 University of Idaho students were murdered at a home near campus. The tragedy has garnered attention and inflicted great sorrow throughout the university, state, and country. To the extent that an answer is required, TikToker denies all allegations in the introduction of the complaint. The parties, TikToker partially denies the allegation in the first sentence of paragraph 1 of the parties' portion of the complaint pertaining to the allegation that TikToker is an individual. What? TikToker admits the allegations in the second sentence of paragraph 1 to the parties' portion of the complaint. Wait, if not an individual, are you a corporation? What does not an individual mean? I've never seen anyone say that they are not an individual. I've seen people say that they don't recognize the authority of the United States government. You guys are saying, oh no, that's a soft sit argument. Is it? Oh, you're right, chat. I misread it. She is arguing that the defendant is not an individual. You're correct. Sorry, I misread this. She is not arguing that she's not an individual. She's arguing that the professor's not an individual. My brain has stopped. Okay. Jurisdiction and venue denies factual allegations. No answer is required because it's a narrative. Okay. Denies all allegations, lacks sufficient knowledge. So this is trying to get to general denials. And getting to general denials. Okay. First claim for relief, more general denials. Second claim for the relief, more general denials. Affirmative defenses. And this is, I wonder if we're going to diverge from the last one or if she's just refiling the same thing she did last time. Here's an affirmative defense. The venue is improper. Again, you're answering. So I don't want to help. This is where I'm torn, right? I'm not here to give anyone legal advice. I'm here to cover documents. But I also don't want to give anyone ideas by covering documents going, that's not how this works. Maybe I just stay there with, that's not how this works. But there are pre-answer motions. And the pre-answer motions, the reason pre-answer motions come before the answer, because once you answer, you're engaging in the jurisdiction of the court. And I'm going to leave it at that. Because there's an argument that the venue is improper because TikToker is a resident of Texas, but this is not the way to make that argument. The venue is improper for this case because the events giving rise to the claims of the defamation are the publishing of TikTok videos that took place on TikToker's TikTok social media page. There's no federal district in which this action may be brought except the United States District Court of the Southern District of Texas. Make that motion then. The complaint fails to state a claim upon which relief can be granted. That's also a different motion. That's not an affirmative defense. That's a motion to dismiss, but okay. I mean, plaintiff claims are barred by the substantial truth doctrine and the incremental harm doctrine pursuant to Mason v. New Yorker magazine. The substantial truth and the incremental harm doctrine hold that if the defamatory statement does no more harm than the true statements about the plaintiff, then there is no actionable claim for defamation. And then goes on to say that professor planned, ordered, and executed the murder of 4 University of Idaho students in the filing. Since the accusations in TikTok videos are substantially true, there is no actionable claim for defamation. She's going with the I said what I said defense. Okay. I said what I said. Plaintiff's claims are barred by qualified privilege. Oh, it's in here too. I'm delighted. That's not, legalese is hard, but that's not what that means. This is not what qualified privilege is. I mean, at least litigation privilege does cover making the defamatory statements again in the pleadings. Like, you're not going to get sued again for saying it again in the pleadings. This is going to have to go to trial. I don't know how this resolves. I don't know how this resolves short of trial. Because this defendant's representing themselves pro se. So they don't have a lawyer to sit them down and say, here is how a jury is going to see this. And it is not going to go well for you. And because there's no one to give you that reality check that might be needed, not all lawyers do that, good lawyers do that, but because you don't have that reality check, how does this go anywhere other than trial? With the TikToker saying what's in this filing, which is, I said what I said, and what I said I'm saying is true. Oh, man. I don't know how else this resolves. Plaintiff's claims, so professors' claims are barred by qualified privilege. The 4 University of Idaho students were brutally murdered without the arrest of the murderers, plural. There's a presumption of danger to the public. University of Idaho constituents in Idaho. Okay. Discovering and revealing the murderers, plural, with the intent to get them investigated and arrested is an act to warn others about harm or danger to bring resolution to the problem. That's not how this works. The statements were made in the best interest of public safety. That's not a defense. TikToker made statements without actual malice. That's a defense. However, I don't think we're at the point where the professor is a public figure. Oh yeah, this is totally a copy paste. We're not going to go through it line by line. We're just going to hit the highlights and make sure it's the same. Amy, this is a great question. Should be able to. And actual malice, again, might not apply here because I don't think this professor is a public figure before this starts. And I don't think the professor did anything to make them a limited public figure. The reason they got thrust into public conversation is because of the actions of the TikToker. But that's okay. I should ask their lawyer about qualified privilege. Qualified privilege permits, I need to send it to Emily Shirts. Don't send this to me. I am not involved. Therefore, qualified privilege permits TikToker to make the statements that in a different circumstance would typically be considered defamatory. I love the doubling down on admitting in the answer that the statements are defamatory, but y'all, listen.
Listen, Linda. The statements would be defamatory, but they were said on TikTok and an arrest hadn't been made yet, so they were in the best interest of public safety. And that means they're not defamatory. Okay?
That's not how that works. Lee, if you have not seen the original Listen Linda video, it is a delight because it is a kiddo talking to his mom, trying to negotiate. And he's like, listen, Linda, listen to me. And it is absolutely delightful. Go look up the Listen Linda meme and where it came from. I don't, I actually, Viking Bear, I love using the Shaggy defense. It happens a lot. But this isn't that. This is, I said what I said, but it's okay. Because it would be defamatory, except that it was in the best interest of public safety, and therefore it's not defamatory, which isn't how this works. Okay. Plaintiff's claims are barred by the parameters of the broad freedom of expression granted by the First Amendment. You mean speech? The First Amendment of the United States Constitution provides that Congress can make no law respecting an establishment of religion or prohibiting its free exercise. Wait. You went to just quoted the entire thing. It protects freedom of speech, the press, assembly. Yes, yes. TikToker used her spiritual brain. This is new. Is this not new? I feel like this is new. TikToker used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of the 4 University of Idaho students and published her findings on TikTok. TikToker is protected as a U.S. citizen to exercise her spiritual connection, abilities, and practices without being barred by the law. Oh, that's why she included the freedom of religion. Huh. Is she going to try to argue that her spiritual connection and abilities are her practicing freedom of religion? Because freedom of religion has to deal with the state and not defamation. Okay. Plaintiff's claims are barred by fraud because they're false, perjurious, frivolous, and claimed with malice. To get away with unethical conduct, adultery, and murder. The defense is, because she's asserting her defenses, we're not at the counterclaims yet. Her defense is, plaintiff can't say these things about me. Plaintiff can't sue me for defamation because saying that what I said is defamation is false, perjurious, frivolous, and malicious because it's trying to cover the truth being, from this TikToker's perspective, unethical conduct, adultery, and murder. Okay. Plaintiff's claims are barred by comparative negligence. Professor committed the allegations that the defendant... What? That's not comparative negligence. Plaintiff professor committed the allegations that the defendant TikToker alleged. I think what she's trying to argue is you can't say it's defamatory when I'm saying it's true, and you calling it defamatory is defamatory. She's tripling down. This is... Plaintiff professor is at least 51% at fault for being accused of the allegations. 51% at fault. The professor's 51% at fault for existing? Oh, no. Okay. So the TikToker is saying that it's true. So the professor's at fault for her saying it because the professor did the things. This is the problem that this professor is going to have. This professor is in a very difficult litigation position. This is a pro per who is not paying an attorney, who I would imagine, and you never know what property they might have to lose at the end of all this. But if they don't have a ton to lose financially, there is no incentive for them to deal with this case in a kind of normal course of get a lawyer and deal with the case. There's no incentive for them to stop saying what they're saying. So for the professor, how do you fight this? Because if they're going to keep doubling down, you're going to be fighting with someone who is not seeing the world the same way that you are. And while they might lose TikToker at a jury trial, at what cost to the professor, who I think, speculation, just wants this to stop? But if you're litigating against a litigant who doesn't have a lawyer, who doesn't seem to give a fuck, and who doesn't seem to think they have much to lose, they're not going to lose a house, a savings, a 401k, a reputation, whatever. If they think they have nothing to lose, you're going to be rolling in shit with a pig. And the thing is, the pig likes it, right? That is the best analogy I've got at the moment, because lawyers use it all the time. So the one who ends up getting hurt is the person with something to lose, the professor. So what do? You spend a lot of money and get where? Where do you get at the end of the day? Maybe an injunction saying, keep my name out of your mouth. At what cost? Like, at what cost? You just end up in the mud in all of this. I feel for this professor. And maybe that's what it is. Maybe filing the lawsuit and bringing this to light is what the professor wants to say. This is what I'm dealing with. I have a tremendous amount of empathy for this professor. I really do, because you see litigants like this, like the TikToker, and the TikToker is like, I'm right. And the TikToker is not backing down on their convictions. And the university professor is like, I didn't murder anybody. You can't keep doing this. Okay. Can she have lawyers awarded to her so her fees are paid by the defendant? She can have her if she wins, she can have her legal fees awarded, but how is she going to collect them? What do you collect them from with the TikToker? How do you collect them? Collecting on this case, I imagine, is going to be tremendously difficult. Plaintiff's claims are barred by illegality because they're perjurous. The TikToker is again arguing that the claims made by the professor and her lawyers are perjury because they are sworn under oath and they are false. That is also not how that works. Okay. The counterclaims look the same as set forth more fully below on November 22nd. As set forth more fully below, November 2022, Ethan Chapman, Kaylee Gonsalves, Xander Kernodle, and Madison Mogan, 4 University of Idaho students, were murdered using her spiritual acuity. This seems to be rewritten a little bit from my memory. Ashley Gouliard uncovered hidden motives, hidden details of the murders. She discovered that Professor initiated, planned, and executed the murders and hired men to help her plan and carry out the murders. TikToker published her findings on her TikTok social media webpage. To evade suspicion for the murder of the 4 students on December 21st, 2022, Professor and the attorneys filed frivolous complaint, this one, against TikToker. The complaint falsified the factual allegations and claims for relief to create a cause of action for defamation against TikToker. After filing the complaint, professor and lawyer published false statements of fact about TikToker in multinational news media outlets to harass, degrade, humiliate, and discredit her, and to deprive her of an impartial tribunal. The false statements of fact published about TikToker portrayed her as someone who defamed esteemed professor by falsely accusing her of murder. The truth of the statements TikToker made about the truth is the statements TikToker made about Professor are substantially true. They then get into the parties. which we've seen. Jurisdiction. You can't argue in your counterclaim that jurisdiction is proper in Idaho while arguing that jurisdiction's not okay. Are we going to, oh no, these are different facts. Because what I don't see are all the facts about the media and the YouTubers. Or at least this is broken out. Oh, there it is. Or at least this is broken out differently. This seems to be substantially the same fact-wise as the first one. Equally as outrageous, but the same. Professor has pervasive power and influence, this is new, due to her prominence at the University of Idaho, Moscow, and surrounding areas. Her PhD from Harvard University and extreme level of ambition also exhibited on her extensive 12-page resume on the university's website and her own website, details some of the work she's done as a public figure and leader. So she's trying to say that she's a public figure. Extreme level of ambition. There is so much that annoys me about looking at a female professor who has a PhD and saying that her extreme level of ambition makes her a public figure. But I am going to skip through that. Academics do a whole lot of shit to be academics. It's like the entire game of academia is to have the longest resume possible. Okay. Professor valued her career and prominence at the University of Idaho and surrounding areas. Of course, as anyone would. Accurately and succinctly stated better than me. Publisher perished. She valued her career. How dare she? The audacity of this academic to value her career and also be married. I am sorry. The female attorney in me is just how dare you value your career? Victim Kaylee Gonsalves was a popular student at the University of Idaho. Her popularity grew as her success grew. Okay. Before her untimely death, her new career and Range Rover added to her popularity. What is happening? I don't remember any of this from the first one. I don't know what is meant by new career. And I don't know what is meant by... I do not like the way that the victims are being brought up in this. And it's making me really uncomfortable. Okay, we're going to keep reading. Because this is different than the last one. Yes, now the chat is hearing popular from Wicked. We have now switched to the other popular from Song. Unfortunately, Stephanie, this is not going to be... This is distasteful. This is ill-advised and distasteful. But this is not going to result in more lawsuits because this is going to be covered by litigation privilege. She's adding more allegations into this answer than were in the last one. Professor feared that the attention that victim Gonsalves got would cause their inappropriate relationship to be exposed. She feared she would lose the prominence she had earned, the career that she had built, and the future she was creating. That here led her to have victim Gonsalves killed. I'm just reading it as it's written. Oh, rage. Victim Gonsalves and the professor met at the University of Idaho when Gonsalves sought mentorship for personal and professional growth. These are just such vast, vague, oversweeping allegations. I grant the motion for DEFCON red. I'm fucking pissed. I try really hard to stay neutral. I'm not neutral on this TikTok defamation suit, but I've told you that from the beginning. This enrages me. Leave the victims out of it. And just doubling down on it it's unsettling. So yes, chat, I grant your motion. For those of you that are new here or do not know, this bumper's a little flashy. I love it. And when the music ends, the flashing does too. So if you are flash sensitive, just know it is a little flashy right there at the beginning, but then it resolves itself at the end of the music. And we are DEFCON red. I know. There's a part of me here that doesn't want to keep going because of the ick, but there's a part of me that's like, this is what's going on in this court filing. This is what's happening. And this is just the continued doubling down. These are the allegations that were made that led to the defamation suit in the first time. And now the response is no. I'm telling the truth. And this is why I'm now suing you for defaming me by saying I defamed you. And that's what this is. I'm not going to get into every single allegation because I think it's abhorrent. Because it gets in, there's a lot of judgment here. There's judgment about same-sex relationships here. There's judgment. So I'm just going to leave that alone, because what we're not going to do is like make shit up about people and then involve shame in all of it. I'm not, if you guys have watched the TikToks, you know exactly what the TikToker has been saying, that the student and the professor had an inappropriate relationship that they didn't want to be exposed. The professor was married, et cetera, et cetera. The relationship took a turn for the worst when Gonsalves was about to graduate college and move to Texas. She was no longer convinced to be in a secret love affair with the married professor. The university did honor the students at the graduation with degrees and honored that, which I think was probably great and hard for the university family to have some to honor that. This is going into what the TikToker says the professor is thinking and why the professor decided to plan a, quote, murder conspiracy. It doesn't say murderous, it just says murder conspiracy. Remember, the police have already said that all of this is not accurate. Schofield hired help to help her plan and execute the murders. She offered financial, collegiate, and career incentives as a reward, using her prominence at the university as a tool. Her offer was accepted. During November 2022, Kaylee visited Moscow to visit her friends before moving to Texas. Wasn't she still a student? Rebecca and her hired help took this opportunity to execute their plan to murder Kaylee and her friends. On November 13th, the plan was initiated, planned, and executed, this says. Since the year of 2021, TikToker used her social media platforms and books to answer questions related to a variety of unsolved murders at random. She used her intuitive abilities and spiritual acuity to get insight on unsolved cases. During TikToker's spiritual research, she was intuitively led to the University of Idaho's history department using logic. TikToker viewed the University of Idaho's history department's webpage. History department professors and associates were listed. So she picked her off the website. During the spiritual investigation, is that another word for a witch hunt? Chat, let me know. During the spiritual investigation, TikToker spiritually, just to be clear, inquired into each person listed on the history department's webpage, seeking their role in the murder of the 4 University of Idaho students. Nearly all of the insight uncovered for each person was about their reaction to the murders except for Professor. The insight for Professor was distinctly different from the... okay, what is the insight? Please tell us. The insight for Professor was distinctly different than that of other history professors and associates. The insight for Professor revealed that she was in a relationship with the victim that broke up and that she initiated the murders, planned the murders, and helped carry the plan out. TikToker sought more information and spiritual insight to help her findings. The answers didn't change. When she was 100% sure of the message, she revealed her findings on TikTok and sent information she uncovered to the police department's tip line. I'm sure this professor sleeps better knowing that she was selected off of the website to be targeted in this way. They're then saying that Professor strategized with her attorney to silence TikToker to evade suspicion, obstruct justice, and avoid criminal investigation into her role in the murders. On December 8th, Professor and attorney asked TikToker in a demand letter to stop posting her content about Schofield's connection. Yes, that's called a cease and desist letter. They asked you to cease and desist. And she said they falsely claimed the information to be false. How does this resolve short of trial? They said it's false, but it's not false. Gouliard published that she did not have to stop posting her content about Professor's connection with the murders because she is protected by the substantial truth doctrine and the broad parameters of the First Amendment.
That's not how this works. That's not how any of this works. That's not how that works. No. No.
This is why the plaintiff's lawyers are calling this a clout circus. On December 21st, 2022, Professor, with the help of attorneys, filed a, quote, frivolous, perjurious claim alleging that Gouliard defamed her with full knowledge that the statements Gouliard made about her were true. So Gouliard is saying, I'm going to prove that Professor knew what I was saying was true. How? And despite being frivolous, the claim sought approximately $2 million in relief. The claims against Gouliard were filed with the intent to deprive her of the right to the freedom of speech. The right to free speech, first of all, is not being infringed with the cease and desist asking you to stop saying defamatory shit. The claim has numerous perjurious statements. A perjurious statement that Professor didn't participate in the murder, a perjurious statement that Professor didn't know the students, a perjurious statement that Professor does not recall ever meeting any of the students, a perjurious statement that Professor didn't have a romantic relationship with the victim, a perjurious statement that Professor didn't order the murder of these students, a perjurious statement that Professor didn't hire a student to plan or carry out the murders. That's not very specific. A perjurious statement that TikToker made false accusations about Professor's role in the murder of the 4 students, a perjurious statement that TikToker decided to use the community's pain for her online self-promotion, and a perjurious statement that TikToker continued to make false statements knowing they were false. You saying that my statement's false is false. And then they quote Yahoo News, Fox News Digital, and other outlets saying what the professor said. Then they quote all of the media outlets that have covered the defamation story. All of them stopped covering the defamation story. They should do it again. Oh, but that might make it more of a clout circus. Wait, there's different YouTube channels listed. Hold on. Now we need to go through and find the other YouTubers that are mentioned. But I love that it's they brought in Law and Crime, multiple YouTube channels. Do you remember? Some of you might not remember. Do you remember when the lawsuit went down with, oh gosh, it was one of the first Ethan Klein suits with Triller, and they were just trying to sue a YouTube channel named Mike. And it was like Mike, the YouTube channel. It's like Mike. The fact that they've just listed multiple YouTube channels, Apple Podcasts, all of them, just the entirety of Apple Podcasts, TikTok pages, Twitter, Facebook users, Instagram posts, Reddit articles, and other social media videos. Mama's Uncut, Find Law, the Daily Mail, The Tab, Similar Worlds websites, Fox News 5 San Diego, you stay classy, San Diego, Pedestrian TV, Techno Trends, Perez Hilton, the AP got way down at the bottom, the Sandra Rose website, AOL. Let's see. They took out some of the YouTubers from last time. I'm sorry, YouTubers from last time. Marquis, you've been released from this version of the lawsuit. iNabber is also no longer in this version of the lawsuit. Interesting. But Lawyer Pegleg Finance YouTube channel is in here. Is there a lawyer named Pegleg Finance on YouTube? All of TikTok, Instagram, and more. I'm sorry, Marquis and iNabber. Apologies. You are no longer listed as people who covered this, except for the fact that you are broadly listed because the entirety of YouTube is listed. TikToker is arguing that TikToker has been presented in a false light. Instead of being perceived as someone who has used her spiritual... Oh gosh, okay. Instead of being perceived as someone who has used her spiritual acuity to make a positive difference in the world and to help solve the case of the murder of 4 University of Idaho students, she was perceived as a liar who used this tragedy for personal gain. Well, now we know why she's mad. TikToker continues to be harassed, cyberbullied, and humiliated online by thousands of social media users because of the widespread defamatory statements Professor and her attorneys made. Weird. It's like people have feelings about the things that you said. TikToker's integrity, spiritual practice, reputation, and livelihood was compromised by Professor and attorneys to meet their goal of evading suspicion of Schofield's role in the murder of the 4 students. Gouliard was deprived of good reputation, business, clients, income, and a peaceful social media presence. Does that exist? Teach me. Family and friends, due to the counterclaims. I have questions. Is this because of the professor's statements, or is this because of the shit that she posted on TikTok? Gouliard received death threats to her email, website, and social media channels. Well, that's fuckery. Bring it against those who brought the death threats. Death threats on social media are always fuckery. Don't do that. Don't make death threats against people. She received unwanted negative calls and emails like the professor did. Here's the difference between TikToker and Professor. Professor had a job and was posted on the university website because she had a job. And this was brought to her door because of what TikToker posted. TikToker chose to post the things. So the fact that she has received unwanted negative calls and emails is because of her posts, not because of this lawsuit. And she chose to post it. So that's the difference, or one of the differences. I shouldn't say that's the only difference. She received tens of thousands of negative comments on her social media pages and message inboxes. I'm not surprised by that. The death threats are fuckery, but other people might have opinions about the things that you said because you posted them on the internet. First counterclaim for the release. This is defamation because of the press release against the attorneys and everybody else. This isn't going to fly. But the professor is going to have to pay to litigate and get these claims yeeted. They're going to be yeeted, but you have to pay to get them yeeted. Second counterclaim for the lawsuit, that's not going to work. You can't sue someone for defamation for things said in a lawsuit, but the court's going to get to address that. And I look forward to it because this court's already gotten a little sassy. I like this judge so far. We've had some sassy footnotes. We've called the things that the court called the things that TikToker posted ill-advised. And there was another one. You guys are gonna have to remind me because my brain totally blanked. Brain, come through when I need you. It wasn't unfortunate, but it was in that vicinity of ill-advised and unenviable. I'm gonna have to go back and find the footnote. It was great, but it was something and ill-advised. Chat will remember before I do. It was not unfounded. I agree that ill-advised is mild. I'll go find it. I'll go find the court's footnote in a minute because I can't remember it, but it was great. Who said help, I'm being oppressed. Thank you for the hearkening back to Monty Python. Let's see the third claim is obstructing justice, conspiracy to interfere with the right to due process and freedom of speech. Off-putting. Yes. Yes, it was off-putting. Thank you, chat. Ding, ding. Off-putting is the word we were looking for. Off-putting and ill-advised. It was very judicial. Off-putting and ill-advised is what the court called the claims of this TikToker or posts of this TikToker. Let's see, this is a very long. Fourth cause of action. Action for neglect to prevent a conspiracy to interfere with the right to due process and freedom of speech. What? Against which defendant? There is a 1985 claim for neglect to prevent a conspiracy to interfere with the right to due process? How? The defendants conspired to prevent a TikToker the right to free speech and the right to due process. A reasonable inquiry would have revealed the fact that the statements made by TikToker were not false and at the very least were not proven false. Defendants used professor's alibi that she was not in Idaho when the 4 university students were being murdered, and the fact that she was driving home from Portland after law enforcement officers discovered the murders. With over 40 years of collective experience practicing law, it is reasonable to believe the attorneys know that professor did not have to be. She's suing the lawyers for representing a client. The alibi is also incomplete with key information missing, like the date and time Schofield booked the hotel, the date and time she checked into the hotel. That's all for discovery. Being psychic and receiving information by intuitive means does not equate to falsity. A reasonable inquiry in the form of a Google search would have revealed the fact that psychics have been used in police investigations and published by the United States Department of Justice. Footnote 2. There's a footnote. Oh, it links it. Psychics and police work. See, There's a difference between what goes on behind the scenes and what you say about people on TikTok, right? Okay. Pursuant to the United States Department of Justice, psychics include clairvoyants, prophesizers, telepaths, palmists, numerologists, graphologists, and metaphysicians. I need to Google what a metaphysician is. It sounds very cool. I have no idea what that is. Both psychics and detectives base their work on intuition to some extent. Dorothy Allison of Nutley, New Jersey, a known psychic, has assisted police in more than 4,000 investigations and has received many letters from law enforcement agencies describing how she helped them using only the victim's date, place of birth, and location last seen. Footnote to an article. But she didn't say it on TikTok. The article was written 30 years ago. Ergo, psychics have been used in police work for decades. The fact that this defendant doesn't see the difference is going to be difficult for the court to deal with. This is plaintiff. This is professor's belief or religious connotations about psychic abilities are irrelevant. A reasonable inquiry reveals that the history and usefulness of psychics goes beyond their religion or beliefs and has been used in police work for decades. Okay, you weren't working with the police, though. Sending a tip to the police line and publishing defamatory statements on TikTok are different. It was disingenuous for the professor to act as if they didn't know how psychic receives information. Huh? Okay. A reasonable inquiry in the form of a basic search engine inquiry. Google it? Your defense is Google it. Okay. At least there's some different claims than there were in the first one. A reasonable inquiry in the form of a basic search engine inquiry reveals the definition of psychic intuition, tarot cards, and its multi-century history. A reasonable inquiry into the basic definition of a psychic negates the statement that Ashley Gouliard has never been to Idaho and has no basis to make truthful statements about the events that occurred here. It's basic information that psychics do not have to be at a place or event to receive truthful information about said place or event. It's disingenuous for professor to allege that TikToker should believe a random comment from a social media user over her own mental or spiritual faculties. It was disingenuous. Okay. It was disingenuous for professor to allege that TikToker should believe that alleged murderer professor who had not yet been properly investigated or caught over her own mental or spiritual faculties. So the TikToker, my brain hurt. I have a headache. The TikToker is arguing that she shouldn't have believed the cease and desist because the cease and desist came from the professor who is an alleged, in her words, who's alleged to do the thing over herself. So she's like, I'm going to believe me, not you. So if you're telling me it's not true, I don't believe that. And so I'm going to keep saying what I'm saying. Well, this is the find out part of the fuck around. The use of the word disingenuous has skyrocketed since the last one. Oh, there's more. Keep reading, Emily. Okay. A reasonable inquiry, this is not one from a search engine today, in the form of asking TikToker by email or phone, not by cease and desist, obviously, would have revealed the fact that the statements TikToker made were not made with malice or ill intent. Malice, I don't think is going to be the standard here. And I don't know if she's using it the way that it's meant in the law. However, not intending to harm someone and harming them are different things. An email or phone call to TikToker would have revealed the fact that TikToker believed the statements she published. This is going to be the defense. I did not make these statements with knowledge of falsity because I believe them. That is the defense here. That is all of this is the defense. Even though this is not in the defense part of the lawsuit, this is in the counterclaims part. It's like, I'm suing you. This is TikToker saying, I'm suing you because I believe what I said is true, and you suing me saying that I'm lying is defamation. Okay. So if I love it when people are like, you should have just called me. I'm sure the professor has no interest, and her lawyers have no interest in speaking to the defendant in this case. You should have just called me, and I would have said, I believe that this is true. Great. Additionally, if the counterclaim defendant watched the videos, okay, I find myself saying this sometimes. I'll occasionally see a comment on YouTube, a stray one, and I'll be like, tell me you didn't watch my video without telling me you didn't watch the video. It's that comment. I love that that's now made it into a legal filing. Additionally, if Professor had watched the videos TikToker posted about the professor's role in the reasoning and reason for initiating, planning, and executing the murder of 4 students, it would be apparent that TikToker believes everything she posted. If you had simply watched the videos, you would know that I believe that what I say is true. Ergo, it can't be defamatory. Duh. Oh, gosh. None of the counterclaim defendants made any attempts to call or email TikToker to inquire the reasons for the allegations. I understand why they didn't. They only made demands for TikToker to cease her freedom of speech and prevent Professor from being investigated. Each defendant, including the lawyers, had the wherewithal to cease the action from being filed and to prevent the perjurous statements about TikToker from being made. None of them conducted bare minimum due diligence. Okay. This again doubles down on the claims. Oh, we've gotten to lawful law almost. This is doubling down that the professor initiated, planned, and hired men to murder the victims here. To have a legal claim against TikToker, please tell us what the law is. To have a legal claim against TikToker, she had to lie about her involvement. Otherwise, she would have no cause of action. A claim that is only lawfully allowed due to the perjurous statements impedes upon judicial fairness. Yet, the professor and lawyers negligently filed a claim without due care or regard to judicial fairness for the TikToker. Oh, the audacity. Oh, the audacity. Y'all are impeding my judicial fairness, even though I'm making all these allegations against you. The mere acceptance and existence of the legal claims against TikToker is already a deprivation of her right to due process, which includes an impartial tribunal. The unlawful, careless, and negligent actions of the counterclaim defendants impede upon the right of TikToker to be treated just and fair. Really? The perjurous statements the professor and lawyers filed prevented the court from rejecting the claims made against TikToker. You didn't make a motion. The court doesn't just yeet claims. I wish they had yeeted this one. They should have yeeted the answer. They didn't, and I understand why they didn't under the law, but still. Some of these are going to get yeeted. These counterclaims are going to get yeeted. We're not done with the counterclaims yet. God help us. Defendant counterclaim plaintiff alleges that she has suffered loss of business, clients, income, and a peaceful social media presence. I didn't know you had a right to that. Family and friends. Maybe listen to the family of friends if they have thoughts about this. The damage to her reputation and subsequent social media harassment caused by Professor caused TikToker emotional distress and loss of enjoyment of life. You didn't bring that claim, though. This is not the place for that claim. Also, you chose this. Plaintiff seeks recovery for financial damages. Fifth counterclaim is a 1983 civil rights claim for deprivation of due process under the 14th Amendment of the Constitution. Where's the IIED claim then? If we're just doing all of this, malicious prosecution, what else is in here? This is the longest damn answer. 61 pages. There is so much more in this than the first one. We're in it together, y'all. The civil rights claim is interesting. She's being deprived a fair tribunal. I don't know how we're getting there. And I don't have the mental capacity to try to do the gymnastics or the flexibility to try to find how bringing a lawsuit deprives someone of an impartial tribunal, because it doesn't. Malicious prosecution. Sixth claim for relief. This claim is frivolous, or a claim is frivolous when it lacks an arguable basis in either law or fact. She's arguing that this is not based in law or fact because the professor did what she said she did. And she's saying these are substantially true, therefore this is malicious. That's not what that means. Let's see. As intended by the professor and lawyers, TikToker's reputation to include her spiritual acuity, integrity, character, humanitarian efforts, spiritual practice was ruined due to the frivolous claim filed against her being assumed as legitimate by multinational audiences. So she's arguing malicious prosecution and the damage being loss of business. So she's arguing things in a hybrid way, but she should ask her lawyer about this. There's another malicious prosecution frivolous claim. I don't know why there's two, and I don't know how they differ. A substantial part of the events giving rise to the false claim of defamation happened in Houston, Texas, where defendant resides. Defendant posted videos about the professor on TikTok from her home. This is not malicious. This is a motion. Oh, don't help. This is a motion with regard to jurisdiction. She's trying to make a jurisdictional argument under a counterclaim for malicious prosecution, and that is not going to work. But that's what she's trying to say. Hey, I posted it on TikTok. Why are you suing from Houston? Why are you suing me in Idaho? But this is not the vehicle legally for that. This is why lawyers matter. Because again, it might be an argument. Hey, you can't sue me in Idaho. I'm in Texas. We went through that in the state of Washington 3 years ago with a case. Hey, I posted shit to the internet from another state. You can't sue me in this state. So don't. And the court was like, hey, yeah, how do you meet this to not dismiss it and say that this is the wrong jurisdiction? But that's not a venue argument. That's a jurisdiction argument. And that is not a malicious prosecution claim. It is a motion that comes before an answer, but this answer has been filed. So the shit's kind of out of the horse on this now. Eighth claim, obstructing justice and conspiracy to interfere with due process in proper venue. That's not how that works. That's just that's not lawful law. Damn it, now I'm saying it, but it's not lawful law. Let's see if there's anything new in this one. I don't see anything new other than the same argument that this was from Houston, but this is the wrong vehicle for this. It's going to get yeeted by the court. And the court can't fix this, right? The court can't advise. An attorney has to advise. A court can't say, you're trying to make these arguments that go in a motion to dismiss, but you didn't. So the court can't help there. Oh, here. There's that. She actually contemplate. What the fuck is happening? Okay, what? TikToker did not file a motion to dismiss the complaint because a motion to dismiss the complaint for improper venue prevents and prolongs TikToker from being able to file counterclaimants for the illegal deformities conducted by the counterclaim defendants. Additionally, a dismissal due to improper venue does not provide Gouliard with the opportunity to defend herself against the perjurious and false allegations in the complaint. That's not how this works. These are not counterclaims. These are not counterclaims. So TikToker is saying, I have consulted my spiritual attorneys and I did not want to file a motion to dismiss. I wanted to make it a counterclaim, but that's not how this works. You can't make it a counterclaim, but at least she's telling the court, and this is going to be an important part of the record for the court. She's telling the court, look, I knew that a motion to dismiss. I knew of a motion to dismiss. This is fascinating. I knew of a motion to dismiss. I weighed that option and made a strategic decision to not file a motion to dismiss. Instead, I'm filing it this way. That's not how that works. Oh, good. Now I don't feel so bad. Now we've gotten to page, whatever the fuck page we're on. What fucking page are we on? 48 of 61. And we know that this pro se TikToker contemplated a motion to dismiss, which was the proper venue for some of these defenses. Hey, you don't have jurisdiction over me. I'm in Texas. You're in Idaho. That's been waived. So now she's saying, no, I want to bring them as counterclaims. No, you can't. But the court is going to be like, oh, thank God. Because now there is a record that this was a legal strategy. She has said, it's not that I didn't know. It's that I made the strategic call. Fascinating. Fascinating. So she's admitted that she didn't want to make a motion to dismiss. She's subjected herself to jurisdiction in Idaho. She's going to have to appear there in person at some point. She's admitted that these things are defamatory in other contexts than on TikTok. There's going to be an issue of estoppel here down the road because she argued in this motion. God, we never get to talk about estoppel. She argued in this motion that these statements would be defamatory in other contexts. So she's going to have to the court will give her some leeway, but kind of walk the line on, yes, I get that these would be defamatory in other contexts, but they're not defamatory here. Okay. All right. Well, she knew about the motion to dismiss and decided to not go that direction. I need the meme. It's a bold strategy, Cotton. Let's see how it works out. To be a fly on the wall of these lawyers, the plaintiff's lawyers' office, when they read through this together, I hope they also do running commentary with each other, because they're going to sit there going, what the fuck? What the fuck? What the actual fuck? Can you fucking believe this? There's more about the fact that Gouliard didn't file a motion to dismiss. Okay. TikToker was forced to expend time, energy, mental, and monetary resources to legally defend the false allegations in the claim in the improper venue, ergo subjecting her to defend her rights that are typically inalienable, due process. No, you chose. No. You can't argue both sides of this. You chose not to file the motion to dismiss. You can't turn around and complain that you had to defend this. You should have filed the motion to dismiss. Gouliard has experienced extreme mental and emotional anguish due to the egregiousness. Oh, you're upset with the audacity that somebody sued you for defamation. the egregiousness, multitude, and timing of professor's behavior. If you didn't say anything about the professor wouldn't have said anything about you. That's how that works. The multinational news coverage defaming TikToker's character, the defamatory complaint, massive cyberbullying. Are you connecting the professor to the cyberbullying, or are you just complaining about it? Across social media, because of the defamatory complaint, death threats and frivolous claims, they all occurred simultaneously. These things all occurred while the TikToks were being made about the thing. TikToker's reputation was severely damaged across the United States, internationally, and on social media. Those are three different things. Due to the conspiracy to deprive her of her constitutional right of free speech. TikToker was harassed on social media, her website, email, and by telephonic means nearly every day. She received tens of thousands of negative comments calling her crazy, issuing death threats, and wishing she'd get arrested and more. She received unwanted negative calls and emails from strangers wishing her ill will. Just like the professor complained about in her complaint. Strange. Also, don't make death threats against people on the internet. It's fucked up no matter what. TikToker suffered loss of business, clients, income, and peaceful social media presence. 9th counterclaim for relief. She's added some since the last complaint. Action for neglect to prevent conspiracy to interfere. Is this some kind of wannabe weird, like, malpractice claim? Like negligently preventing the conspiracy to interfere with due process against the lawyers? Like the lawyers brought a frivolous claim. And then she cites the Idaho Constitution and rules of professional conduct. I can't wait to see the motion to dismiss on this, though. From the plaintiffs. 10th claim. There's the intentional infliction of emotional distress. She kept hinting at it, and we found it. We knew it was coming. All right, y'all. Let's see what the IIED claim has to say. Somewhere it falls on that fuck around and find out access. But bingo. We knew it was coming. We could see it from the language that was being used. The tort of IIED has 4 elements. Thank you for the lesson. The defendant must act intentionally or recklessly. Has the professor been reckless in bringing a lawsuit after sending cease and desist about this? I'm going to go with no. The professor's conduct must be extreme and outrageous. The professor's conduct in sending a cease and desist and then sending a cease and desist and then following it up with a lawsuit, is that conduct on behalf of the professor extreme and outrageous? Because I'm struggling with it. The conduct must be the cause of severe emotional distress. The extreme and outrageous conduct. The professor's extreme and outrageous conduct is saying, please stop saying shit about me on social media. That's not true. So the attorneys filed the claim. They filed the claim under oath. She said that the claim is defamatory and perjurious because her TikToker's statements are true. And as a result of that lawsuit, as a result of the lawsuit being filed, not a result of her posting on TikTok, as a result of the lawsuit being filed, TikToker is saying that she has been harassed all over, and that she has suffered from emotional distress and loss of enjoyment of life. She seeks to recover financial damages. 11th counterclaim for relief, emotional IIED from the press. So she's suing. What? She's suing the professor and the professor's attorneys for the press coverage of the lawsuit. No. That's also not how that works. So we're going to, oh, she's reiterated all of the press outlets. But they're not the ones being sued. All of Instagram. Vaguely gestures. So she's suing the professor and the professor's lawyers for intentional infliction of emotional distress because this has been covered by the media. The filing of the frivolous claims against TikToker and the mass dissemination press release caused TikToker extreme emotional distress, mental suffering, mental anguish, depression, shame, humiliation, shock, embarrassment, grief, anxiety, and fear. TikToker suffered loss of enjoyment of life because she typically travels to New York for New Year's Eve. Oh, she typically travels on New Year's Eve. Sorry, I read NY and my brain. Because she traveled on New Year's Eve in 2021. So she typically does it. She did it in 2021. On New Year's 2022, she chose to stay inside for fear of life, for fear of her life, arguments, and embarrassment. She didn't want to be yelled at by people in public about her statements on TikTok. So, okay. So she chose to stay home on New Year's Eve. She chose to stay home on New Year's Eve. That's in this lawsuit again. Okay. She has suffered, she says, mental anguish, depression, shame, humiliation, shock, embarrassment, grief, anxiety, and fear due to the false narrative about her being assumed as true by multinational audiences, causing her to stay home and isolate herself more than usual. The filing of frivolous claims against her and the mass dissemination press release with false statements about her encouraged mass harassment against her. Okay. She received harassing phone calls, emails, text messages, comments, and messages on Instagram, messages and comments on Facebook, messages and comments on TikTok, messages and comments on YouTube, messages on her website, www.ashisgod.com. Threatening to inflict harm against herself. Wait, did she threaten harm against herself, or were other people threatening harm against her? Either way, don't threaten people's lives on the internet. It's always fucked up. No matter what the person said. Signing her up for pornography websites, that's like phase 1 of cyber harassment. Expressing wishes that she would self-harm, maliciously misdiagnosing her as insane, maliciously misdiagnosing her as crazy. I don't know if that was diagnosing or name calling. I'm going to go with those being name calling. Maliciously misdiagnosing her with schizophrenia, psychosis, expressing the desire to have her arrested for her allegations, and sending her indecent videos of body parts, including male genitals. Well, that does happen when the cyber harassment happens. Sometimes the internet's going to internet. Again, I do not stand by anyone making death threats against anyone. I think there's much more, I don't know. You can express your, hey, this is bullshit to somebody without wishing them harm. The filing of frivolous claims against her and the mass dissemination press release caused harassment against her by the initiation of a petition to have her arrested that was signed more than 10,000 people on change.org. I'm surprised that the change.org petition wasn't to have her removed off of the internet. Instead, it was to have her arrested. Unfortunately, you can't have people arrested generally for defamation. Did she file a false police report? I don't think she did. A multitude of random people sent messages to her family and friends seeking to have her committed and held in a psychiatric facility and to get her personal address and allegedly have her arrested by Idaho law enforcement. She continues to be harassed, cyberbullied, and humiliated online by thousands of social media users because of the widespread defamatory statements by the professor. I think we're having a cause and effect mismatch here. Her integrity, spiritual practice, reputation, livelihood was compromised by the professor and her attorneys. She was deprived of business. These are all repeats. Prayer for relief. Oh, good. Here's the prayer for relief. Mass press release with a statement that Gouliard approves to every news outlet that Schofield B. Gouliard was covered and to social media outlets, all of Facebook, Twitter, TikTok, Instagram, Reddit, and all others, correcting the false claims made against the TikToker. She wants the internet to apologize to her. She wants an internet apology. She wants a retraction and a correction by the internet. Okay. Mass press release, including every news outlet this lawsuit was covered by and social media, with an apology that she approves for all the accusations made against her. She wants a retraction, a correction, and an apology. Past, present, and future compensatory damages, punitive damages, financial relief for non-pecuniary damages. I want to know if she knows what non-pecuniary damages are, or if she's just like, oh, everybody always asks for this. Attorney and court fees for a judgment dismissing plaintiff's claims for improper venue. No, you've ceded to venue and jurisdiction. For an order imposing sanctions against the attorneys. For summary judgment, you have to make a separate motion for that. Pre and post judgment interest. And all other such relief as the court deems equitable, signed by pro se litigant, TikToker. I wanted to make sure the certificate of service didn't have her address on it. Okay. That's an adventure. And I can't quit this case. I am horrified, fascinated, intrigued, saddened for the professor that's going to have to spend the money on the lawyers to deal with this. I cannot wait to see what the motion to dismiss looks like. And we'll cover that another day. This lawsuit's not going anywhere quickly, and this was filed today, so we're going to have some time to wait for the motion to dismiss, but I guarantee you I will be checking just about every day because I very much want to see how the professor's lawyers respond to the, what was it now, 11 counterclaims? Including suing them because the media said things. Oh boy. 11 counterclaims. Yeah, we live in Idaho now. I hear it's nice. I've been to Idaho. Idaho's lovely. Hope you all enjoy Idaho because now we live there. We're going to get to questions. Y'all have questions and I've seen a lot of them and we will get to them now. So now is the time. Now is the time for questions. All of you, I need to remind you, if you have not, Miguelina, no worries. If you have not yet done the YouTube things, liking and subscribing and all the things, go for it. Miguelina, it's with the auto flagging. We're kind of all good. StreamYard has made this easier for us. So I've got questions. You've got questions. We've got questions. Oh, this has been a 3-hour stream. Let's get to questions, shall we? It's because I added this claim in because it was filed this morning and I couldn't help myself, but I also spent way more time than I anticipated on the rabbit hole that is the Chippendale case. Look, man, when I get fascinated, we're just in for a 3-hour stream. I just couldn't. Jolene, I saw your question in the chat. Why did you leave California for Tennessee? I have 2 podcast episodes on the audio Emily show, back before I renamed it, talking about our move to outside of Nashville. So it's lovely here. All right. So, questions. Octo, I reminded everybody at the beginning for Law Nerd Alert, but it's the only way to get your pre-sale, your early access to my collab. So if you would like to get it before public access starts, you need to get on lawnerdalert.com now, because if you do not do it today, it is going to be too late. And then I will talk to you about the public on sale when it goes on sale. Question, do you think the court will throw out the counterclaim? I think the court will throw out, I think most of the counterclaim can't stand. There's no, a lot of these things, there's just no claim upon which relief may be granted. So I don't see how most of this counterclaim stands. Would I need to go through with a more fine-tooth comb if there's one or two that the court might let get to summary judgment? Maybe, but I would need to go through them more carefully. Most of those are going to get yeeted because most of them are not causes of action. So they can't. Wow today. Clearly this is trade undress lawsuit. This was about the Chippendales suit. Yes, it was for trade undress. The levels of nerd in that super chat are so flawless. I absolutely love them. So we're going to go through some of the questions. Why isn't this illegal? It's a civil suit. This is the TikToker's response to a civil suit. Is defamation illegal? No. Can words be illegal? Rarely. And in specific circumstances, yes, words can be illegal. That's not what's happening here, though. So this is the professor's only recourse is filing the defamation lawsuit and going forward from there. There's not much else the professor can do, which is why I have a tremendous amount of empathy, because what do you do? I suspect you might have a almost judgment-proof defendant here who, it's not like you can take their house. What are you going to do if they just won't stop? How do you stop it other than trying to maybe file a lawsuit and get the word out that these things are defamatory? But the damage is done to the professor, right? And most people can read it and be like, well, this is clearly bullshit. But also, if the professor wants to move to other universities, is it possible that other universities, or even move up within this university, are like, look, man, we just don't want the smoke of the attention from this. Like, it's just not worth it to deal with the controversy. Like, I'm sorry that this person said this about you, even though it's not true. It's just, it's untouchable. And then you might not even know that that's a reason you got passed over for promotion or for another university position or what have you, because now there's a taint. And how do you get rid of that? And how do you account for the opportunities you don't get because your name is now associated with scandal through no fault of her own? So, Stephanie said, but I believed it happened, so it's not defamatory, has strong AH vibes. And that's, Amber Heard never really argued, I believed it happened. And also you have the malice standard in that case, which, different than here, makes it even harder. But we didn't see much of that defense from her. I'm still surprised we didn't. TikToker needs to unlearn the term unintentional tort, or needs to learn the term unintentional tort. I hope your headache goes away. This gave me a bit of a headache. Trying to process the nonlinear arguments were like trying to put myself into, okay, what is trying to be argued here genuinely? Because there are arguments woven into that. Hey, you don't have proper venue or jurisdiction here is what's trying to be argued. But then when we got to I intentionally didn't make a motion to dismiss, it's like, well, good luck then. You've ceded jurisdiction. Question for the gag order. Does it matter that it doesn't seem to gag the media, just the lawyers and law enforcement that they want to talk to? They are saying that the gag order is overbroad. So yes, it matters. You can't really gag order the media, but this is how these gag orders work. They're arguing it's overbroad. So no, it doesn't matter that the media is not specifically named, because it does seem to extend to victims' families and stuff. And so that might be the overbroad part. Alex said, I'm calling it right now, y'all. Trial of the century right here. Look, if this goes to trial, I am going to Idaho. I'm going to Idaho. It's in federal court. It's not going to be streamed. I will go sit on those hard ass pew-like benches in federal court. I've never been to the Idaho federal court, but I'm sure it's lovely, but I'm also sure the seating's not comfortable, and watch this trial. I am riveted. I can't believe the judge is actually entertaining this TikToker's lawsuit. You'd think a real judge would throw it out. Dave, I appreciate that, but the judge can't. The TikToker has been sued. This is the TikToker's answer and counterclaims. The counterclaims mostly might get thrown out, but there still has to be due process for it. So there has to be a motion for it. So yes, a lot of those counterclaims might get yeeted by the court, but the plaintiff has to make a motion. And the TikToker didn't bring this lawsuit. The professor brought the lawsuit to stop the TikToker from continuing to defame them. And so the court just can't sua sponte throw it out. There has to be a motion. So Jolene's like, Emily's setting up a tent in Idaho. No. We'll be at least at a decent Airbnb. Could professor request an evidentiary show cause hearing? There's nothing to do a show cause hearing on yet. It would be a motion to dismiss first. So we'd start with motion to dismiss. That's what I think will be filed by them next. Question, sorry if it's been asked, it's okay. Can the trial not be brought forward somehow? Would it be the sensible thing to do? I think you're talking about the TikToker. They can't really speed it up because there's a whole discovery process they have to go through. So no, they can't really rush this to trial more. And in the civil case, things get kind of backlogged. I'm sure we'll get a discovery order and see when the trial date is set for soon. So yeah, but no, they can't really speed it up. Civil takes a while, which is why it's so financially draining. It really is a shit situation that the professor is kind of between a rock and a hard place. What do you do? Do you let the TikToker continue defaming you? Do you not file a lawsuit? Or do you fight it out knowing you're never going to recover anything? Moo Boy Moo said, hi, Emily. Thanks for the laughs today. I needed that question. How far are you in Zelda? No spoilers. Are you enjoying it? I am enjoying it. I had not played Breath of the Wild for a while, so getting back into the game mechanics in the early phases of the game are fun. I'm not very far in. I have not had a ton of time to play. But when I'm done here, I'm going to go eat lunch and then I'm going to go play. Well, no, then I have to populate tomorrow's podcast. Then I'm going to go play. Tracy said, I really want to know if this goes to trial, what would the venue be? Because I'm in Houston and I would totally go. This has been filed in and is proceeding in Idaho. Can she file harassment charges? The professor chose not to. I would need to look at what the harassment laws are in Idaho, if that would be the best way. The cyber harassment laws are inconsistent and they vary state by state pretty greatly. And that would be a state lawsuit. That could be more difficult than bringing the federal lawsuit. So I'm not sure why the choice was made. I would need to look at Idaho law to tell you that more specifically. Is that an option? Maybe. JG said, would the gag order stay in place, make it harder for his appeal later? Should Kohberger be found guilty? And would it be better for it to stay in place? I'm trying to figure out how I want to attack it. So is it better if it stays in place? It needs to be narrowly tailored to address whatever they're worried about. So the process needs to be proper. Would the gag order staying in place make it harder for his appeal later? No, it wouldn't. It really, I covered this. I don't remember if it was on Tuesday or Thursday, but I covered the ins and outs of what media interference in a trial looks like. And we're not even close to that in this case. So no, the gag order staying in place wouldn't make an appeal harder for him because the appeal would be on other issues in the criminal trial. Hopefully that answers the questions. A bit behind, why won't they stream the Kohberger trial? I don't know if they will or won't, Renee. They haven't decided that yet. We're not even close to the trial yet. We are at preliminary hearing and I don't know how they're going to do it. I think they'll probably do a delayed release and release things in the evening. That's what I think they're going to do. Though they could, if the media attention gets too intense, they could say, no, fuck it, we're not doing it. Niche, I think it's Niche Mac. Thank you. Said, is that still a huge amount of evidence for murder 4 people. Sorry if it's a stupid question. No stupid question. I'm not an English speaker and really don't understand the justice system of the US. First, thank you for your super chat. I'm sure watching me is not always easy for non-native English speakers because I talk really fast. But it's not a huge amount of evidence, but yes, it is 4 murder cases in one. But the amount of evidence turned over, that's a lot of video. But considering it is a quadruple homicide, I would expect that it would be a lot of evidence. So I'm not shocked by that. No need to apologize. Not a stupid question. Thank you for asking, and thank you for the super chat. Discovered you during my 1L year, now graduating from law school today. Congratulations! Hold on.
Yay, law school graduation. Good job, Mallory. Woo!
I genuinely learned a lot from your commentary. Thank you. You're welcome. For context, all the data in the Library of Congress amounts to 15 terabytes. Wow. Well, video can be big files, I guess. Ashley said he has the right to presumption of innocence, Kohberger. There's a huge danger of being tried in the public forum before jurors are chosen, in my opinion. Is there case law supporting that? I would assume so. Ashley, I covered the case law that the media was arguing last time, and it is a balance between the defendant's rights and the media's rights. And I covered that. I think I covered that on the podcast on Wednesday as well. So the podcast is really where I broke some of that down, but he has the right to a presumption of innocence, but his right to a presumption of innocence is in the court, not necessarily in the court of public opinion. He has a right to a fair and impartial trial with a fair and impartial jury. Does the media coverage make it impossible for him to find a fair and impartial jury? That's what I think his defense is going to argue. But we've seen lots of high-profile cases with more media coverage than this, with higher profile players, and they've still found people who are like, I have no idea what any of this is about. And I talk about that more in last week's Emily show that's up on the channel now. Feel you on living in LA. That's how I ran into George Takei. That's one of the fun things about living in Los Angeles, right? A G-string stuffer for Vegas. Casey Cat, thank you. Vinny G also thanks you in advance. Sarah said, spent all last weekend relaxing in Montego Bay, Jamaica with the hubs for our 15th anniversary. So I'm really behind on supporting. You're good, Sarah, and working to get caught up. May I suggest that you check out the Quick Bits channel? I have a Quick Bits channel because these streams get really long and Quick Bits are just the Quick Bits. It's a great way to catch up. Welcome to Your Fantasy Podcast. That's all the dirt. Okay, I'll go check Welcome to Your Fantasy Podcast. It sounds like behind the scenes of the industry. Jessica said, I unfortunately was the one who found out that my father was cheating on my mom with her cousin. Oh God, Jessica, I'm so sorry. That all of that sucks, but you should never be in the position where you're the one who discovers that. I'm so sorry. That is a very difficult thing. Jessica said a friend left her husband during the middle of the night while he was still sleeping on the last night of their vacation. When she found pictures and text messages to and from another woman, he had to figure out how to get home. I mean, and what to do with the rest of his life and how to check himself. Casey Cat said, I have my collab box and love it. The box itself is epic and on my bookshelf. Mine will be on my bookshelf soon. For those of you wondering what the box is, you have to be on the email list. You have to go be on the email list. You have to go be on the email list. These, for the public, I will be letting you know how to get these later this week. But if you are like, Emily, I need to know everything, lawnerdsunite.com. Claire said, same happened to me. One wrong text. It was better than the FBI. 12 years wasted. I was better than the FBI. I bet you were 12 years wasted, but I am so much better off. I am so sorry that happened. But yes, knowing is always better than not knowing, I think. Caught an ex-husband cheating, got a friend to take me to get his car and drive it home, then waited for the call. Can we do a live watch party tomorrow for all the reaction? Maybe he's member only so we don't get struck again. I don't know how to do a watch party. I might do a members with my live reactions from Vanderpump. I will figure out how to do it. So EDB, you need to talk to Moffat on Money. Creator Rob at Lawn Lumber introduced me to. He bounced for the Dave Matthews Band. No way. That would be fantastic. I think that would be a very interesting way to do bouncer work for DMB. I am so excited DMB is coming to Nashville. TikToker should have used ChatGPT to write her counterclaim. Don't give ideas, chat. Don't help. Don't help. Don't help. Don't help. So let's see. Oh wait, I rewound too much, but still over an hour behind now. Hello, goodbye. Off to be replaying. Hello, goodbye. All right, all of it. Stop it. No chat GPT. My teacher brain is melting. I just got an update to Grammarly that has like an AI writing function in it now. It looks like it's combined kind of a chat GPT option into it. But with all of that, on Thursday, I'm not sure what we're talking about yet. I'm going to go down the rabbit hole with what's going on with Chippendales. We need to do an Amber Heard insurance update. And that is what I am intending for Thursday. But there's some other updates I want to look at, including Brittany. So that's for Thursday. Tomorrow's podcast is all about Murdaugh and the fucking audacity of it all. You don't want to miss it. I will be premiering it on the channel at 11 a.m. I will be here with you in the chat. Other things are happening this week. You want to stay in the loop at lawnerdsunite.com and be subscribed here and hit the bell. We are working on other ways to keep you in the loop notification-wise, and you want to be the first to know. Thank you for that. I am going to go play Zelda and get some lunch. That is what I am going to do. So with all of that, thank you for being here. Thank you for being Law Nerds. I'm almost done with my coffee. I hope you are done with your coffee. And cheers. Thank you for being here. You guys are the best. Okay, last super chat. Thank you, Cassie. If she believes what she said is true, is that a sound argument to make at trial? Oh, we're going to pickle our way out. I promise for Pickle Day, we'll pickle our way out. I will put up the pickle poll next. The jury will have to determine that it was not false. But this isn't going to have a malice element. And we will talk about the malice element next time we talk about this, because proving it's not true for someone who's not a public figure is going to be enough. So her saying, but I thought it was true, so there's no malice, isn't going to fly when malice is not an element here. It's easier to prove defamation against a non-public figure. And she never argued here that Rebecca Schofield is a public figure. Rebecca Schofield has said that she's not a public figure. So there's already an argument over whether there will be or not be a malice element, and I don't think there will be. So that would go to malice, but there's no malice. So when there's no malice, it's just that it's not true. And the police have come out and said, this is not true. And I imagine would end up testifying in the civil trial saying, this is not true. So we'll talk about malice more on Thursday. That is a good idea, chat. Thank you. And I'm going to go play Breath of the Wild. Question. Do you think professors' attorneys have a drinking game going? Probably not. It's too much. It's too much WTF to have a drinking game. They still have to work. All right, chat. Thank you for being here. I will see you all live on Thursday. Take care. Stay safe. And, enjoy the video games. All right. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams.
Y'all, I forgot to pickle. I promised the pickle. I'm sorry.
I forgot. I know. The poor pickle. I didn't forget. I'm sorry. I'm sorry. We'll outro twice. It'll be fine. The pickle feels so disrespected. I'm sorry. I'm gonna go put up the poll. We're gonna name the pickle. It's all gonna be fine.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.